In leave to mention a matter, my lord, for extension of an interim order which expired on Friday, my lord.
Why Friday not mentioned? I have called the total list. Sorry.
My lord, it was
Sorry. I have called the total list. Nobody was there.
No, Lordship was right in calling the total list, but my lord, we are bound by the resolution.
No, you are bound by the resolution. All the advocates have appeared who the interim
My lord,
order
the
is to be
client will
extended.
suffer unnecessarily.
What
my
can
lord.
be done? Suffer, you tell the bar council. Clients are suffering with the bar resolution. I have taken, till 11:30 I was here.
No, Lordship
And
is
I have
correct.
called,
always,
that's why
always, my
I
lord,
called all list, total list of 250 matters.
my lordship is right in what lordship is saying.
Even then, I advise my court officer, if any advocates will come for extension, let me know.
My
But
lord,
nobody has come till
I am
4:30. I was
not,
in my chamber.
joining issue there. Lordship is absolutely correct in
Then-
what lordship is saying. But lordship kindly
See, I am
appreciates at
totally
times, my lord.
against this cease work. Totally against the cease work. You go, but interim order, whatever it is, come to the court.
My lord, next time we'll remember this. Kindly, my lord, for this last chance, my lord, kindly, my lord, extends this interim order. We will not, my lord, whatever
You file
be
the
the
writ
resolution.
application, court has passed an order, given some direction, again you are on cease work. And subsequently, then you are coming for the mentioning the matter, for fixing the matter. My whole day was gone in the...
I shall remember this, my lord. Kindly, my lord, don't penalize the client for this, my lord. Kindly, my lord. Last time, my lord.
Let the client know what the advocates are doing.
It's not the fault of the client, my lord. It was our misunderstanding.
What the advocates are doing.
My lord, at times, my lord, lordship understands.
Since my practice, I am totally against this cease work.
We'll keep this in mind, my lord. Kindly, this time, my lord, permits, my lord, the order to be extended, my lord. This is, my lord, the last, my lord, extension. But I'm mentioning upon notice, my lord. I have given notice to the other side. লিস্টে আছে লিস্টে থাকার কথা কত নম্বর আছে লিস্টে লিস্টে আছে বুধবার ছিল
Learned counsel for the plaintiff has mentioned the matter and submit that the interim order was up till 22nd of August 2025. But due to the cease work called by the bar association, the matter could not be mentioned for extension of the interim order. Accordingly, he placed for interim order. He submitted that the notice of mention has been also issued to the defendant, but none appears on behalf of the defendant. In view of the above, for the interest of justice, the interim order is extended till 23rd of September 2025 or until further order, whichever is earlier. Let the matter remain in the list.
My lord, I'm very grateful, my lord.
Let the matter remain in the, if it is come in the list.
It comes on Fridays.
You are appearing?
1, 2 and 3.
Only the different number?
1, 2 and 3.
Yes.
May I as well as kindly to mention a matter for inclusion. It's an order 13 application of the plaintiff. The suit got adjourned on 2-3 occasions because there was talks of settlement going. Minutes of meeting held, parties came, they gave the date of payment when they would make. Still they are not paying. New motion any day, normal course. Not praying for any time, but any day, tomorrow, day after, any day, whenever. It's a new motion.
Third correct. To be mentioned. New motion.
Leave Millard to mention Millard the not about Dotco matter Millard. It was there at 10:30 fixed on Friday. Other side was not there. My lord, recollect.
Come on Friday.
Friday.
Come on Friday. In kan le lo Natabar ka na. Friday to be mentioned.
My lord, I appear for the applicant CA 22 in this matter. Not about the matter. I appear for the applicant in CA 22. So the other, as a subject to correction, my lord, the other CAs were supposed to come on Wednesday. So okay, so could it be on 27, my lord, because I'm led by Mr. Moina Ghosh, my lord. He is available on Wednesday, my lord. Could it be on
20?
27?
27, my lord had indicated, my lord.
27.
27, my lord. If it could be, well, for subject to let it be on convenience.
It is a non-commercial matter, na?
Company matter.
Company matter. Then company matter is no. Wednesday nahi ho.
Wednesday, my lord, kindly don't, my lord.
Then come on third.
The only thing is that my lord dictated the order. It's lying. Only my lord, with regard to the interim order, my lord, may I pay for one thing? May I come back anytime today? 3:25.
But other side.
No, the Mr. Boss is here. My lord, at 3:25, 3:20, my lord, before 3:30 matter.
No company matter. The record is
required. My lord can treat this because it was to be mentioned on my lord Friday. My lord,
correct.
the other side was not there.
Correct.
My lord, if order is drafted, is lying with my lord's stenographer.
एक काम करो इसको ना 28 को कर दो टू बी मेंशन. हाँ ठीक है, इसको 28 को टू बी मेंशन में कर दो, उनका कंपनी वालों को इन्फॉर्म कर दो 28
At 10:30, my lord.
at 10:30 to be mentioned.
Okay.
Yes,
My
next.
lord, kindly to mention, your lordship, item number 37, my lord, which was the Purti matter your lordship had taken up on the last day, on
37.
Thursday. 37, my lord. Well, it's an application for subpoena, your lordship,
Hmm.
which we have filed, the defendants had filed, my lord.
Hmm.
Well, at the only, it was appearing as to be mentioned on Friday, my lord.
Hmm.
Well, at the problem is that if this person is transferred from Kolkata, my lord, we will have difficulty in contacting the person, my lord. It was to be mentioned, my lord. Kindly can it come as to be mentioned
Once the
tomorrow?
court is fixing a to be mentioned, you are taking the resolution for not to appear.
Well,
What purpose would be server keeping the matter in the to be mentioned?
my lord, short matter, your lordship.
What short matter? Why you not appear on Friday? Several advocates are appeared. Several advocates have appeared through the virtual mode whose matter is urgent.
My lord,
Either you go by the resolution or you go by the list of the court.
I will
I already stated if the matter is not taken November, it will be taken in November. But you are unfortunate. You are fortunate that your matter is on the list. I don't know because I all directed the all Friday matter will go in the month of November.
will kindly take it up as to be mentioned tomorrow, your lordship, as a last chance, my lord, as a last chance.
Just keep it in mind the total bar. Any resolution taken, but this court will take up its own matter. If they will not appear, then I will pass an order for 2 months. Let you continue with your resolution. Yeah, see, on Friday you are not appear. Now you are mentioning the matter to fix the matter. Where the court will fix the matter?
My lord, it
You
was
know the time period of this court.
I appreciate your lordship. It was appearing as to be
Let it,
mentioned on
let
Friday.
it remain in the list. If it call, it will call. Not yes, call the other matter. Yes, what is the mentioning other?
May I be permitted to mention an undefended suit, Millet? One GA6 was filed to disclose certain documents at a subsequent stage, Your Lordship. On 5th August, Your Lordship has granted me the leave to comply with the order, Your Lordship. It was to treat the part of the plaint and amendment of the order 11, Your Lordship. Your Lordship, leave was granted. Your Lordship, we have written to the registry, my lord, but your Lordship department is treating as an amendment, Your Lordship. Now, my lord, the difficulty is my day to carry out this comply with the order has expired, Your Lordship. I'm only praying for 1 or 2 days extension. It needs
When the order was
5th
passed,
August, Your Lordship.
huh?
5th August.
So why you not completed?
Your
by-
Lordship, in between these 3 days of holidays were there, Your Lordship. Somehow,
Where is
Your
the order?
Your Lordship, may I hand over the order?
As per the prayer made by the counsel for the plaintiff, time to comply with the order dated 5th August 2025 is extended for a further period of 1 week from date.
Your Lordship, may I pray for leave to file the written statement and the master summons? Your Lordship.
When you receive the
Lordship.
writ of summons?
Your Lordship, I have received it on 25th of April 2025. Your Lordship, the last day, the 120th day was on 23rd of August, which is a Saturday. So, Your Lordship, in terms of section 4, Your Lordship, the court, when it reopens, so, Your Lordship, today is technically the last day. So, Your Lordship's kind leave subject to acceptance.
Leave is granted. Leave is granted to file the written statement in the department with in course of the day, subject to acceptance.
Lordship. Grateful, Your Lordship.
Lordship, with item number 86, Your Lordship, the party has filed the disputes amicably. We have already filed the settlement agreement, and along with a joint compromise petition along with the 96, Your Lordship, may be disposed of or
Yes.
orders will be passed.
Matter is settled, entered into terms of settlement. So you want to disposal. It is not in the list.
Item number 86.
86, Your
Huh?
Lordship.
86.
Item number
86, Your Lordship.
Srijan Private,
Yes, Your Lordship.
SRMB Srijan. इसको थर्सडे नहीं फ्राइडे को टू बी मेंशन में रखो. Item number 86, Friday to be mentioned for settlement.
Grateful, Your Lordship.
Your lordships, kindly may be permitted to mention item 8 of your lordships today's list. 8, your lordship. My junior had mentioned this on Friday. Your lordship had directed us to mention it today. Today it is appearing for witness action, your lordship. We wanted to mention it on Friday because the witness has taken ill. So we are carrying the doctor's prescription. We would be seeking an accommodation, your lordship.
Okay.
But
Come
it
at
is fixed
3.
today at 3 p.m., your lordship.
Which for the other side?
Lordship, I am mentioning upon notice.
Okay, come at 3 p.m. I will.
I
be
shall
there.
come out. Wait.
Yes.
My lord, I am appearing for the plaintiff in this matter.
This matter
Yes.
is coming at my instance, if your lordship recollects.
Yes.
My lord, we had mentioned the matter, thereafter matter came in the list, your lordship said, I mentioned in the first week of August, your lordship said, let the matter appear on 20th. If any of the other defendants wishes to make their submission, we'll hear them, otherwise, so far as 5, 6 are concerned, my lord, because we say that in terms of the appeal court's order, your lordship has heard us, hearing complete, notes of argument
So
exchanged,
regarding 6 and 7 is over.
over, completely.
Any other defendants application is
The submissions by D11 and 12 are also over. We have submitted our
but they have, the plaintiff has given right to say 10 and 11.
No, my lord. That is yet to be done, my lord. For defendant number
Yes, 11 and 12, your lordship has heard me extensively. 10, your lordship has also heard, to the best of my recollection.
No, plaintiff has not given reply to your 10 and 11 and 12.
My lord, my learned friend is appeared for defendant number 11 and 12. My lord, Mr. Bhattacharya was appearing for defendant number 10.
10.
My lord, we are supposed
That's
to
right.
reply to defendant number 10,
Hmm.
11 and 12.
Okay.
And for the other defendants, my lord, they have taken out appropriate
That is correct.
My lord,
That is correct.
my lord, if I may,
Your lordship, I may appear.
my lord, defendant number,
Appearing on behalf of the defendants number 13 and 14. And I'm filing the affidavit in reply, if your lordship kindly accepts.
Affidavit in reply of
Regarding the vacating application, GA 11 of 20, GA-Com 11 of 2025.
that will see
But
later.
We
one
have
thing I
already
should indicate,
served a copy of
but
the
one thing I should
written-
indicate, your lordship has been pleased to close the rights of the defendant number 8 and 9 and 13 and 14 to file the affidavit in opposition. To circumvent that, they have filed an application for vacating. To that, my lord, the affidavits are complete. Without prejudice, my lord, we have filed the affidavit that cannot be done. What they couldn't do directly, they couldn't do indirectly. My lord, may I file the affidavits in opposition
Of,
to their application?
11, 12,
of
GA.
It was served long back. It was served long
of
back.
GA
GA 11.
GA 11.
on your filing.
For GA 11 and 12, for GA 11 of 2025, defendants number 13 and 14. The
What you are
affidavit
filing?
reply, your lordship.
My lord, with regard to the order
আপনি অন্য ডিফেন্ডেন্ট একটা ডিফেন্ডেন্ট করে হোক একটা
Yes, yes.
My lord, by order dated July 31st, my lord directed, the envy of the department is directed to place the written statement, which you have filed. Whether that has, I am
That I will see to that.
not, that is
Uh,
competent.
Plaintiff has filed affidavit in opposition in connection with GA 11 and 12. 11 of 2024, 12 of 2024. Counsel for the defendant number
13 and 14.
13 and 14 filed affidavit in reply of both.
No, your lordship,
Of
only
GA
GA 11.
11 of 2024. Let the same be kept with the record. It is found that there are altogether how many defendants? 12. 12 altogether 14 defendants.
Your lordship.
14 defendants. But with regard to hearing of the GA number 1, GA number 1, Mr. Bose,
Yes, my lord.
GA number 1, that is the interim application, comma 6 and 7 have completed their argument. The other defendants have not completed their argument. Accordingly, let
Your lordship, D10, D11 and 12 have also
let the
completed
matter
their submissions.
hearing of GA1 with respect of all the defendants except defendant number 6 and 7. As regards 6 and 7, let the matter fix for orders with regard to GA1.
But only
I
thing
make a submission. May I make a submission, your lordship? D11 and 12 has also completed its submission.
Plaintiff has not completed, sir.
Yes, plaintiff has not. That is correct. That is correct.
One humble submission regarding GA 11 of 2025, filed by defendants number 13 and 14. We need to place that application before your lordship. If your lordship kindly fixes a date,
Saturday 10:30.
if your lordship kindly fixes a date.
Saturday 10:30. I am fixing. I will take the special leave from this the chief. 10:30. Not ready.
Yeah, lordship. Right.
Then
My lord, is it your lordship's pleasure that we file the written notes, my lord, for the
Yes, my
others? Or may I file the notes of argument for the defendant numbers 10, 8 and 9, 11 and 12, and 1 to 5? 4 sets of notes.
We have to argue.
We have to argue.
Yes,
We have-
then you argue, then you file. No, only with regard 6 and
Otherwise,
7.
we are ready.
6 and 7 you filed
6
already.
and 7, 5, yes.
Filed in the
Otherwise, we are ready with all our notes and ready to argue.
For your lordship's convenience, the note of both parties in respect to our hearing was filed on 2nd of May. Both of us have filed our notes.
2nd of May.
Plaintiff has filed, so have we.
2nd May.
2nd May. Can we take paragraph 8 of second May order?
Notes of argument on 2nd of May.
Yes. Yes, that is there
But wait.
for orders. Yes, now call the matter.
Grateful, man.
Deeply obliged, Your Lordship.
Think the matter, my lord.
Let the order come, then I will fix. Let this application be disposed of, then I will fix the other matter.
Then the interim order is till the 2nd of September.
2nd September.
If your lordship
Okay, you
kindly
mention it.
consider-
If it is not disposed of by that time, you mention it, I will. Yes, call.
My lord, 2, my lord, I appear for the plaintiff.
For the defendant number.
My lord, this is that matter, my lord, where the issue of 106 notice, your lordship deferred, and now it has been approved, my lord, your lordship's view. So, my lord, now the applications have to be heard out. Our order 13A, our order 13A application is there for summary eviction. They have an order 7 rule 11. So, my lord, any day subject to. No, order 7 rule 11 is not disposed. Order 7 rule 11 is not disposed.
My client who had suffered few lordship and with the observation of your lordship and thereafter before the special bench, they are not taking steps to perform or test it 1 second before the Honorable Supreme Court, my lord. If because it's a question of law, it must be, my lord, said.
Correct.
So they are taking steps for that.
Because
If
this judgment will decide the fate of the whole country.
there are
That's
32 suits right now pending in the regular division, all of the same issue, have the same issue.
I have been briefed in 2 matters where your lordship passed the decree. The clients have come to say now this decree cannot because it's passed in the regular division. It should become that was the law at that.
So clients is taking steps for bringing a finality to this issue, my lord. So kindly, if lordship, I do not say that kindly adjourn the matter, but my lord, if some time can be granted for that issue to be
You're
decided.
not prepared, still you're not prepared.
Not fine.
It is over.
We are 3 months, my lord, is there. They are taking steps. I had made the.
No, then
preliminary draft,
at
but
least
to be-
at least a day could be fixed after the vacation at least. Then we can-
Counsel for the parties submit that. There are interlocutory application being GA1 and GA. Several applications are there. How many applications?
GA2 and GA3.
There are interlocutory application being GA2 and GA3 of 2024
Yes,
Yes.
both are today.
are pending for adjudication and praying for fixing the matter. Learned counsel for the defendant submit that the defendant is intending to prefer an SLP against the order passed by this court, which was duly affirmed by the by the special bench. In view of the submission made by the counsel for the parties, let the matter. So after vacation, I am fixing. Give the date. Vacation after hearing of. Let the matter appear on.
But any day barring the 3rd if it could be done. Any day.
Let the matter appear on 6, 7, 8 November. 10th November. 11 November at 2 p.m.
Number 2 p.m.
for hearing of GA2 and GA3.
GA2 and GA3.
GA3.
I'm so grateful.
आ जाएगा. Yes, next.
I appear for the plaintiff. This is that application which your lordship had heard for a deposit of occupational charges as last paid rent. I had completed my submissions.
Yes, madam.
On last day, my lord, your lordship asked me to take instructions, my lord, that I have already taken, my lord, at the present, my lord, the suit is in dilapidated condition, my lord, my client is not been able to use it my lord, commercially, my lord. And my lord, in the opposition also, my lord, we have admitted some rent, my lord, area rent, my lord, after deduction of the extra corporation charges that we have paid, my lord. That is in page 33 of our opposition, my lord. That comes to 49 lakhs 96,000 something, my lord. And my lord, with regard to the present rent, my lord, my client.
Fine.
And with regard to the present rent, my lord, which comes to something 1 lakhs 24,000 something, my lord, that, my lord, the present rent, my lord, is, my lord, my client is liable to pay, and my lord, he can.
Current rent.
Current rent, my lord, the present charges.
You admitted 12 lakh 48,000.
No, my lord, 12 lakh 48,000 is not admitted, my lord. 1 lakh something is my admitted
Per
rent.
month.
Yes, my lord.
So since when?
My lord, no, my lord. One thing, my lord, in my written statement, I have taken a defense that I have paid the entire corporation charges for the entire billing for some years, my lord. And that should be deducted. That is my written statement. That is my counter claim, my lord. If
Counter claim will be decided.
Stage, my lord, the counter claim will go, my lord. If that exorbitant rent is allowed, my lord, my counter claim will go. It's an issue.
What is the monthly rent, madam?
Monthly rent is something 1 lakh 24,000, my lord. I'm
1,24,850 for 2 floors.
Yes, ma'am. 1,24,850.
Ah.
My lord, I have given the calculations also. If your lordship comes to page 32 of my opposition, my lord. My lord, paragraph F. My lord, we are not. My lord, we are ready to
Paragraph?
page 32, my lord, paragraph F.
Yes.
My lord, first for the my lord,
Yes, the respondent is liable to pay the arrears monthly rent from effect of September 2020 payable at the rate of 68,100.
Yes.
In respect of second floor and 56,750 in respect of third floor.
Yes, ma'am.
Correct.
That comes to 1,24,850, my lord. That comes to 1,24,000.
That's what I'm telling. 1,24,000 per month.
Per month. That is, my lord, that I have to pay, my lord, as per as I'm currently occupying the premises.
Since September 2020.
Yes, that is there, my lord. But we have also set out a claim, my lord, if your lordship comes to the other, that we have paid a corporation taxes that is excess of 24 lakhs 94,398, my lord. That, my lord, we have set out a counterclaim to that. Well, that to be decided at the main, my lord, we are admitting the 49,000, 96,602, my lord. If your lordship comes to the next page, page 33, my lord, same paragraph, next page, my lord. My lord, that we are admitting that 49,000, 96,602, that we can, my lord, that is admitted, that we have to pay. That is area, we are admitting that. In our opposition also, we are admitting.
No. See, you have admitted that the second floor is monthly rent is 68,100.
Yes.
Correct. And the first floor of 56,700.
Yes.
In total 1,24,850.
Yes.
Correct. So September 2020 the monthly rent is due. Correct.
Yes. That is correct, ma'am. That comes to 74 lakhs 91,000.
Correct.
Yes, madam, 91.
Madam,
we have already paid KMC's taxes extra for the entire billing. That is to be decided whether we have paid or not in the suit. That is the issue to the suit, my lord. And we have set out a counter claim for that. My only prayer is that, my lord, if your lordship allows her at the interim stage, my lord.
Okay. In that case, you pay the 74,91,000.
That is.
I am telling. Let here. You pay the 74,91,000, out of which they will utilize the 49 lakh. The remaining will be with the registrar.
My lord, at this juncture, my lord, if your lordship passes an order, it will be difficult for my client to pay that such an exorbitant amount, my lord. If easy installments is also granted, my lord, that will be.
What is the agreement says?
Well, the agreement says, my lord, but we have also.
What is the agreement says? What is the monthly rent?
My lord, that is there, my lord.
Then?
My lord, that if your lordship kindly grants me that 49,000, my lord, my client can pay in installments.
Okay, then I will dispose of on merit, madam.
And my lord, one more thing, my lord, if your lordship kindly disposes of remaining, my lord, I want to cite two judgments, my lord. One with regard to that the interim stage, my lord, well, the final release cannot be granted. That your lordship knows. If your lordship permits me, I can grant cite that judgment, my lord. And my lord, another, my lord, with regard to limitation, my lord, with regard to the that, my lord, after 3 years, the rent was to be increased by 10%, my lord. That, my lord, first time that rent came to their knowledge in at 2021, my lord, first notice was issued for that increase, my lord. There, before that, they accepted the current rent, my lord, as was 1,24,000 per month without any objection, my lord. With regard to that, my lord, I want to say
Correct. That's why, madam. See, first you appreciate the case. What is the case of the plaintiff? The total rent of first floor and the second floor is 1,24,000, 1,24,850.
yes.
Correct. It is the total rent. You are also admitted. Now you are taking the plea, the 1,28,000, including the total property tax of the building. That's why you wanted that an amount of rupees 24,94,000 is to be deducted. But you have paid the monthly rent since until this August 2020.
Yes.
You have paid the monthly rent of 1,24,850 up till August 2020. You have not stated, write a letter, no, I am paying this rent along with the property tax.
Yes, well, property tax, they, my lord, they used to.
Let. Now you are telling, you are claiming that in the counter claim. So in the counter claim, when the court will decide, it will, that will.
Kindly, my lord, let the
And
application be.
one is one. Second thing, they are claiming with regard to the 10% extra after the 3 years. You are telling that you are not paid. So that is also the matter of trial. These two are the matter of trial. Now with regard to the admission of the last monthly rent, what you have paid, 1,24,000.
Yes, my lord, admitted. I
Then-
can't deny that. I can't deny
So
that.
that
Is
the court is,
admitted. I can't deny that.
that the court is going to pass an order 1,24,000 from September till today, and they continue to pay.
Kindly, my lord, for arrears, my lord, from September to August 2025 for the arrears, my lord, for arrears, my lord, only, my lord, 49th. It's my prayer before your lordship. Thereafter, my lord, your lordship decides.
Yes, where is the judgment? Show me the judgment.
Yes, my lord, this is the interim stage judgment, my lord.
Where is the plaint?
Yes, yes.
GA का है GA? GA नहीं है तो ये हुआ है. That is affidavit. Where is the GA? Yes, GA is here. Here. Here is.
And it's the shortest judgment.
Just you come to the plaint. Come to the plaint. What is the prayer A?
Eviction, my lord.
Eviction. So the court is not going to pass a decree for eviction at this stage. Now kindly come to B. Sum up pleaded in paragraph 51. Kindly come to the paragraph 51. So this court is not passing this order. This court is only passing with regard to the last payment rent, last paid rent. Now kindly come to the C. Main profit. The court is not passing any order for
That
main
much.
profit. So how your judgment is applicable? They are only asking for depositing of the admitted rent.
Admitted treatment at 1,24,000. That I have to deposit. That
Correct.
I have no other way.
Yes. So
That
that is the thing.
Deposit that I have to for monthly rent. My lord, with regard to only, my lord, that if as I have set out a counter claim to that effect, my lord, with regard to the corporation, my lord, taxes, that, my lord, I am only praying that it be delayed at a time. My lord, if your lordship decides that I have to pay at the time of final trial also, when the degree of eviction is passed, I have to pay that amount also.
Madam, I think this court is not able to understand you.
My lord, I'm sorry, my lord. Yes, I'm sorry, but if at the time of final, my lord, if your lordship decides that I have to pay that 79,000, that taxes was not adjustable, then I have to pay.
Madam, this code is not on that, on fact. This code is only with regard to the last paid rent.
Yes.
And the admission made by you that it is the 1,24,000. That is the only question.
Yes.
Tell me on that way. What do you want to submit on that?
On that, my lord,
There you may made a counter claim, but the admitted fact last the August 2020 you have paid the 1,24,000 of both the floors, first floor and second floor. Correct. Now in the affidavit also you admitted this is the monthly rent. Now you have made a counter claim stating that 1,24,000 including the property tax of the KMC.
Yes, ma'am.
KMC.
May I say one thing, my lord? As the application has been kept pending, my lord, it is only at an ad interim stage, my lord. My lord, let me deposit the current rent, my lord, and this admitted one, my lord, at the time of final hearing.
What is the current and as per your submission?
My lord, 1,24,000. That I have to pay. That I have to pay. I am with regard to only that 79 lakhs for 91,000, my lord.
What 79 lakh? Where from you got the 79 lakh?
74 lakhs 91,000. That, my lord, that rent, my lord.
The arrear for 60 months calculated from
that arrears you will not pay.
That I will not pay, my lord. Let it be decided at the time of. Let it be at the time of final hearing of the application, my lord. And for 49,000. After deducting that, my lord, 49,000, 96,602, my lord, which I have stated in my opposition, my lord, at page 33, my lord. That, my lord, at this stage, my lord, and if your lordship decides otherwise, I have to pay that. I don't have any other options.
Yes, what is the submission in the your GA?
Just 3 submissions, my lord. The first, your lordship has seen the prayers in the plaint. This is not in a nature of final relief, so the judgment that she has cited, my lord, perhaps is not applicable to the facts of the instant case. My lord, the next point of submission is that on the last occasion, your lordship had said that the arrears, it fell from your lordship that the arrears can be deposited, month by month payment can be made on the agreed rate, which they say is the last paid rent. The 10% increase, your lordship will not order at this moment. At the final hearing of the application, your lordship will consider on affidavits. My lord, the third thing that fell from your lordship was, with respect to the arrears, your lordship will also grant them installments if they so desire. My lord, and the occupational charges which we are claiming, your lordship had indicated on the last day that today if we pray for prayer A of our application, which is deposit of the arrears, your lordship had clearly indicated that I will not perhaps grant occupational charges as claimed in B and C. I will only ask them to deposit the additional 10% as security. My lord, today in reply, her submissions are twofold. The main that she says is that she has a set off come counterclaim to whatever amount she has paid. My lord, the lease agreement, which is a registered document, if your lordship just takes one clause with regards to KMC charges, which is at page 30 of my application. At best also, my lord, this cannot be a submission that the rent will not be paid in view of what has not been deposited or deposited in KMC charge. But page 30, so part of the registered lease deed, clause 7 at the top, that the lessee shall be paying municipal taxes and or any other rates and taxes as would be levied by the concerned authority or authorities from time to time in respect of the demised flat. My lord, this part of KMC charges is additional to the admitted agreed rent, which your lordship will find at page 28, clause 4. That the lessee shall pay to the lessor without any demur rental of rupees 30 per square feet amounting to 1,36,200. My lord, we have been accepting admittedly a lesser rent, 8,000 lesser, 1,24,000. Hence, I have not even said that 1,36,000 is what we seek for the deposit, because the last paid was 1,24,000. My lord, now this, my lord, read with clause 7, the municipal charges, even assuming if they may have paid in excess, today, my lord, their counterclaim come set off cannot be secured by saying that amount they will not deposit. My lord, the 74,91,000 which they have admitted in again in their opposition, my lord, at para 32. My lord, if your lordship takes their opposition, para 32. Now, my lord, the written statement and other pleas become irrelevant after this categoric statement at para 32, page 32 of their opposition. Page 32, para F at the bottom.
Yes.
My lord, the last last sentence. Thus, the total amount of arrear rent is amounting to 1,24,850 payable in respect of the aforesaid flat for 1 month, and the total amount due from September 2020 to August 2025 is 74,91,000. But the defendant respondent is liable to pay after such adjustment of the KMC taxes which the plaintiff petitioners collected an extra amount of 24,94,398. My lord, my respectful submission would be, my lord, in view of this submission, my lord, an order be passed to this extent, 74,91,000, my lord. I shall not come in the way or bargain for installments, my lord, as much as your lordship wants to grant them, and the regular rent of 1,24,850 without prejudice to my rights, my lord, be deposited month by month. Lord, this is all that today, my lord, I am pressing.
Yes.
And no, not that. My lord, and your lordship on the last occasion had granted us time to file the affidavit in reply, my lord, for considering the other prayers, which your lordship said that after affidavits, your lordship will consider, my lord. So today, my lord, I am pressing prayer A and partially prayer B of my application, my lord. Prayer B, which contains
Prayer A and prayer B is the same.
my lord, I apologize. A and C, my lord. My lord, C, if your lordship. My lord, why I say C, my lord, because A, I have not couched it in a way of arrear charges, my lord. That is why, my lord, I'm just.
I will
Yes,
continue.
deeply. That is.
If your lordship so decides, my lord, kindly give me some installments, my lord.
So these are 70 now as per your admitted case, not admitted as per the calculation.
As per the calculation,
74 lakhs. 75 lakhs.
75 lakhs.
Correct. 75 lakhs. And now you have to pay continuous from month to month till the disposal. So you tell me how much amount you will pay per month?
Areas, my lord, 20 installments, my lord.
20 installments.
This was.
My lord, because my lord, you have to pay the current.
By that time the suit, if this court is having determined, the suit would have been disposed of.
My lord, it's my prayer, my lord. If your lordship decides otherwise, I don't have anything to say, but it's my prayer, my lord. It's a heavy amount, my lord.
Within 10 installment you pay.
10, my lord, not 15.
7 lakh it will come.
My lord, 15, my lord, not
8
10, my
lakh,
lord.
8 lakh per month it will come.
If I come with an extension of time to deposit areas, my lord, that will be a
What can be done?
It's 15 installments, my lord.
Oh, no, sorry.
My lord, 15 installments, my lord.
Then continuous you have to also to pay. This areas plus month by month. 1,24,830 month by month. Current. Till the disposal, because you are in occupation of the premise.
Plus this 15 installment.
Current plus installment. Not 15, 10 installment. Okay, I am giving 12 installment, no problem.
10, 20. My lord, if your lordship consider 15, my lord, 15.
The plaintiff has filed the present application being GA Com 3 of 2025, praying for an order directing the respondent and directing a defendant to pay the admitted rental amount of rupees 12,48,500 for the second and third floor of the suite premises for the period between September 2020 till date, and also to pay and also continue to pay the monthly occupational charges for the same rate till the disposal of the suit. The plaintiff has also prayed for other prayer, but this court is of the view for the interim measure. This court can only consider the prayer A and B of the present application. Counsel for the plaintiff submit that plaintiff has brought to the notice of this court to the agreement entered between and the deed of lease entered between the plaintiff and the defendant, dated. What is the date of the deed?
My lord, 1st April
1st April 2010.
wherein it is, wherein clause 4, it is agreed between the parties that the lessee shall pay to the lessor without any demo of rupees 30 per square feet, that is rupees 1,36,200 per month, calculated at the rate only in respect of the entire second and third floor of the premises in question, totally measuring an area of premises in question. Full stop. The defendant has filed affidavit in opposition, wherein the defendant has agreed that the monthly rent of the second floor is 68,100 and second floor, and the monthly rent of the second floor is rupees 56,750. And next third floor, second floor is 68 and third floor is 56,750. In total, rupees 1,24,815 being the last paid rent. Last paid rent. It is also admitted that the defendant has last paid the monthly rent in the month of October 2020, August 2020, and since September 2022, 2020, the arrears is pending. Arrears is pending with regard to both the floors. Learned counsel for the defendant submits that though the monthly rent is rupees 1,24,850 with regard to the both floors, but defendant has taken out a counterclaim claiming that 1,24,850 includes the municipal tax. He's telling.
Oh, that's not the.
I am recording. Include the municipal tax, and as such, that the total due amount rupees 74,91,000 is to be deducted, and as such an amount of rupees 24,94,398 is to be deducted from the total arrears of rent of rupees 74,91,000, and the defendant is only liable to pay rupees 49,96,602 from September 2020 till August 2025. Had the learned counsel for the respective parties peruse the materials on record. It is full stop. The plaintiff has relied upon the agreement entered between the parties, wherein the monthly rent is fixed at monthly rent of both the floor is fixed at rupees 1,36,200, but the defendant is paying only 1,24,850, which is the last paid rent, and without prejudice to the rights and contention of the parties, the plaintiff is ready to accept the said rent for the present. The plaintiff has also brought to the notice of this court to clause 7 of the said lease deed, wherein it is mentioned that the lessee shall be paying municipal taxes and or any other rates and taxes as would be levied by the concerned authorities or authorities from time to time in respect of the demise premises. By referring the said clause, the counsel for the plaintiff submit that the KMC taxes is not includes in the monthly rent, and the defendant has to pay the monthly rent in excess to the agreed monthly rent between the parties. Had the learned counsel for the respective parties peruse the materials on learned counsel for the defendant further submit that if this court will pass an order for paying the arrears of monthly rent at the rate of rupees 1,24,850 from the month of September 2020 till the month of August 2025, and further to continue to pay the monthly rent, being the continue to pay the occupational charges of the said premises, the plaintiff may be and the defendant may be allowed to pay the arrears in in 20 installment. In 20 installment. Had the learned counsel for the respective parties peruse the materials on record. This court find that though as per the agreement the monthly rent is rupees 1,36,200, but the defendant has paid the last monthly rent for both the floors at the rate of 1,24,850. 850. The defendant has also admitted the said amount and also admitted that since the month of September 2020, the defendant has not paid the arrears of the monthly rent. Accordingly, the defendant is directed to pay the arrears of monthly rent at the rate of rupees 1,24,850 from the month of September 2020 till the month of August 2025 in 12 installment. 12 installment. And the plaintiff and the defendant is also directed to pay the occupational charge at the rate of 1,24,850 per month of both the floors without prejudice to the right and contention of the parties till the disposal of the yes. In view of the above direction, prayer A and prayer B of the instant application is disposed. Prayer B is the same.
Yes,
A and B is disposed of. As regard the other prayers, the same will be decided after hearing and decided after exchange of affidavits.
My lord, may it be recorded that I have submitted on instructions, my lord.
Yes, submitted.
No, my lord, may be recorded.
Yeah. The concept. I will record.
My lord, just one thing, my lord. They have filed their affidavit in opposition, my lord. Time be granted for us to file a reply, my
In
lord,
which?
before. In this application.
application.
The defendant has filed affidavit in opposition in connection with GA 3 Com 3 of 2025. After serving the copy to the counsel for the plaintiff, prays for time to file affidavit in reply. Let the affidavit in reply be filed within 2 weeks. List the matter on 16th September.
My lord, could it be 3 weeks, my lord, for this affidavit?
3 weeks.
My lord, after
3 weeks.
application, my lord.
I will not.
3 weeks. Okay, 4 weeks. 4 weeks. Let the matter appear on 6th of November.
My lord, just one prayer I have been pressed for. My lord, the default clause, my lord, if they don't pay this, because they have not been paying for 5 years, my lord.
It's when record karo. It is made clear that if the defendant failed to pay the said areas of monthly rent and current occupational charges as directed above, the defendant shall be liable to pay interest at the rate of 12% per annum.
Your Lordship, can you allow Mr. Chatterjee?
Yes.
My lords, I just have one request. I have only been briefed in this matter, my lords, in the morning today.
Yes.
I understand, my lords, that this is this contempt petition, my lords. It has been coming before my lord for a while.
Yes.
If my lords will only allow me to come back to my lords within 10 days, maybe in the middle of September, perhaps I could come back with some sort of.
Have you a conference with your client?
My lords,
Give the answer to my question. Have you conference with the client or not?
My lords, I haven't had the.
When you had a conference?
My lords, I haven't had the opportunity to do that, my lords.
Then you need not to speak, sir. I will not allow.
My lords, just
because you are not aware with the how your clients are violating the order from every date.
Just one.
Sorry.
My lords will, as if I can just convince my
That's
lords.
why first I could put the question whether you had
No,
a
my lords,
conference.
I have
no conference, then you are acting upon the instructing lawyer. Instructing lawyer is I should say on full court. But I restrain.
My lord, he has come from Delhi, my lord.
Maybe Delhi or maybe foreign.
And he has come.
The law will not change before this court.
I have explained everything, my lord. Your Lordship will not
Maybe
take
you
me
may explain. Have you informed what your client has
I
done?
have told everything, my lord, about the matter, my lord.
Okay, let the
course,
warrant
he
be
has not-
issued. After 1 month, we'll see to that.
But
My
Your
lords,
Lordship will
because-
not take me.
Please, if you appear, you accepting the brief, see the conduct of the client and see the orders passed by the court. Then you mention before this court.
I have explained to you.
Then you are appearing. So let you whatever submit. I will hear you. Yes, whatever what your
But
submission.
just one judgment, if I may be allowed, my lord.
Give the judgment.
My
Yes.
lords, will have paragraph 10, my lord,
Yes.
on page 6.
Hmm.
My lords, willful conduct. My lords, the Honorable Court says, this is the apex court, my lords, willful introduces a mental element
Hmm.
and hence requires looking into the mind of the contemner by gauging his actions, which is an indication of one's state of mind.
Hmm.
Willful means knowingly, intentional, conscious, calculated, deliberate, with full knowledge of consequences flowing therefrom. It excludes causal, accidental, bona fide, or unintentional acts or genuine inability. Willful acts does not encompass involuntary or negligent actions. Act has to be done with a bad purpose or without justifiable excuse, stubbornly, obstinately, or purposely. It is to be distinguished from an act done carelessly, thoughtlessly, heedlessly, or inadvertently. Does not include any act done negligently or involuntarily. The deliberate conduct of a person means that he knows what he is doing and intends to do the same. Therefore, there has to be a calculated action with evil motive on his part, even if there is a disobedience of an order. But such disobedience is the result of some compelling circumstances under which it was not possible for the contemner to comply with the order. The contemptor cannot be punished. My lords, the only submission.
I am not punishing. I am only issuing the warrant. Let him come and comply with the order. I am not punishing. I am not sending him into jail today itself. But what is the punishment? Warrant is punishment?
My lords,
No, I don't think. Warrant is punishment. Tell me. You came from the Delhi. You tell me warrant is punishment.
no, my lords,
not?
no.
So what the court said? I will issue the warrant
Very well, my lords.
because you have not been properly guided by the instructing lawyer.
Your Lordship will not make this happen. No, I have never done in my 40 years.
Sir, this is the 4th time you have changed the lawyer.
As well, no, my lord, I am not.
It is the 4th time you have changed the lawyer.
I have
Sorry
not
to
changed the
say.
lawyer, my lord. I am
Now you bring the
advocate
lawyer from the Germany or America.
My lord, I am advocate on record in Calcutta, my lord. If the client has gone to somebody in Delhi, my lord, they can.
So why you continue with the advocate on record if your client is not within your hand?
Yes, my lord, I can retire from the matter, my lord. I have
If your
retired.
client is which is not within your hand and not complying with the order and not taking into seriously of the instruction of the lawyer, why you are continuing with that?
Yes, my lord, I can retire from the matter.
No, the court will not dictate you retire.
No, I have retired in this matter earlier, my lord. I can again retire.
So again, yes, you can again.
Yes, my lord.
When you
Your
find that
Lordship
the court is soft, you file the wakalatnama. When the
Lordship
court find that the
Your
court is
Lordship
very
can
hard,
record
then
my
you
statement
withdraw
and
the
with my
wakalatnama.
firm, Your Lordship can record. I am asking for leave to retire. Your Lordship can allow me to retire. But Your Lordship will not take anything personal, my lord. In my so many years of practice, my lord, I don't indulge this kind of.
I find in this matter you have done that.
Your Lordship's observation about me is wrong, my lord. Perhaps I have not been able to.
Initially, you bring the one advocate.
have
Secondly,
never-
you bring the other advocate. Third, you bring the now he is the fourth
I have
advocate.
never indulged. Nobody in this court can say I have indulged in any sub practice in my life, my lord. Your Lordship should not have this kind of observation about me, my lord. And I'm not in dearth of a belief, my lord. I can always retire. Your Lordship can note down here and now. I'm praying for leave to retire.
Yes, by which order, Mr. Gupta?
Yes, my lord.
Has been
26
given time.
26 June 2025. May I hand up a copy, my lord? He personally appeared
20 June.
26th June. And your lordship would recollect he had appeared, he
Yeah.
went into the box, he prayed time till the 15th of August. Principal balance outstanding is 4 crores, plus interest has swelled up to in excess of 1.5 crores. Going by the rate calculated in the affidavit submitted by them, not the rate claimed by the petitioner, by the affidavit rate.
Yes. The initial order, where is the initial order? First order, 1711. When they are given undertaking and the amount was settled.
Kindly give me a moment. 17th November 2023. May I hand up, Malad?
7 November, yes.
Your lordship has got it? Yes.
By an order dated 17 November 2023, the alleged containers number 1, 2, and 4 have agreed to pay the total amount of rupees 8 crores to the plaintiff/petitioner. Petitioner. Full stop. Out of the 8 crore, the alleged container number 1, 2, and 4 have paid
4 crores.
4 crore. 4 crore. The matter was taken up for hearing on 26th of February, 26th of June 20, 4 crore. Lastly on
13th. Yes, I'll just give the date. Last payment is 11th of June.
Lastly on 11th June.
Yes.
Lastly on 11th of June. क्या बोला?
2025.
Lastly, amount was paid on 4th June 2024.
Only one thing, they have already also filed an affidavit to this.
2025. Full stop. Full stop. The order dated. पहले वाला order क्या बोला? First order dated
26th June 2020.
First order. क्या बोला? The order dated 17th February 2023 was passed on the affidavit filed by the alleged contemners.
17 November 2023.
17 November 2023 was passed on the affidavit and undertaking filed by the alleged contemners. By 11 June, they have paid it, and the last payment was made on 11 June 2025. The matter was taken off on 26th of June 2025. And on the said date, the alleged contemner was present in court and he was examined in person. And on oath, again, he has stated before this, submitted before this court that he will clear the principal amount along with interest by 15th of August 2025. Accordingly, as per the submission made by the counsel for the alleged as per the submission made by the alleged contemner in person, the matter was fixed on 21st of August 2025. On 21st of August 2025, the matter could not be taken up for hearing. Accordingly, the matter is fixed today. When the matter is taken up today, the alleged contemner is not present, and the learned advocate prays for 10 days time to make 10 days time to make payment. 10 days time to make payment.
My lords.
Sure.
My lords, you can allow me just a little more time than 10 days. I will come back to my lords.
Not come back. I am asking only 10 days to pay the amount or not.
My
because
lords,
as per the order, 15th August is over.
My only request, my lords, instead of 10 days, if I can be allowed to come back with the payment to make the payment, say maybe by 10th of September or so.
I don't think so. क्या बोला? Prays for 10 days time to make some payment. When this court has asked the learned advocate who is appearing today on behalf of the alleged contempt number 1 and 2, whether you have a conference with the alleged contemnor, comma, he submits that he has he has not held any conference with the alleged contemnor. He is submitting on the instruction of the instructing advocate appearing in the matter. This court has a bad experience with the alleged with the conduct of the alleged contemnor.
Lord, he has not acted
Since the November 2023, since the month of
I am
November
meeting him in the court
2023.
for the first time, my lord. I have met him in the court.
So from who you have taken the
I
instruction?
don't know, my lord. I
Where
have
is your
met him in the
vakalatnama?
court.
Where is your vakalatnama?
Vakata is my vakata. He is a counsel. He's
That's why you have said that he will appear.
My lord, he is appearing as a counsel, my lord.
Just he has stated that he has taken instruction from the advocate, appearing advocate.
My lord, I have met him in the court only. Your lordship,
Sir, the first question I put him whether you have instruction. Now he has taken from the
instructions from me, my lord. I have only explained the order and the the event.
So how you are appearing, sir? You are not having a vakalatnama?
My lords, I am not having a vakalatama
Then?
from the client, my lords.
Police, क्या बोला? No, उससे पहले first paragraph ना, learned advocate appearing for the alleged contemnor prays for interim days time to make some time in this court. With 1, 2, and 4. Whether fully. So बाकी के दिन this court has also inquired from the learned advocate who is appearing on behalf of the alleged contemnor whether he has a vakalatnama or not. He submit that he has no vakalatnama. The learned advocate, what is your good name, sir?
S.R. Kakrania.
The learned advocate who is advocate on record, the learned advocate Mr. So-and-so, who is advocate on record, submits that he is only having a vakalatnama and he has not given any instruction to the learned advocate who is appearing for the alleged contemnors. He has only met with the present advocate in the courtroom only. Correct?
And I've explained the orders also, my lord.
Fully. The learned advocate who is appearing before this court today only on behalf of the alleged contemnor 1, 2, and 4 has no vakalatnama, and thus this court find that he has no power to submit on make any submission on behalf of the alleged contemnor. Thus, this court is not accepting the submission made by the learned advocate who is appearing today on behalf of the alleged contemnor without the vakalatnama.
Your lordship can name him. His name is King.
This court find that the conduct of the alleged contemnors are very bad. Now and then they are coming before this court and making giving an undertaking that they will clear the dues, but when the date is fixed for making the payment on the date fixed, they will not appear, and only on the strength of the warrant they are appearing before this court against the warrant. Today also the alleged contemnor has not appeared, though on the last occasion the alleged contemnor undertaken before this court on oath that he will clear the amount by 15th of August 2024, but no amount has been paid till date. Considering the above, this court find that, and this court has no other option but to issue warrant against the alleged contemnor 1, 2, and 4. The petition is directed to immediately file the requisites in the department for issuance of the warrant against the alleged contemnor 1 and 2 through the superintendent of police of
Trichur police station.
Tiruvallur or Trichur?
Trichur police station, Andhra Pradesh.
Trichur district. Trichur district, Tirupati.
Only one thing, my lord. Everywhere where your lordship mentioned alleged contempt, it should be alleged contempt number 4.
1, 2, and 4. I will take it because he is taking the 4
yes,
total.
But 4 had personally appeared on.
Okay. So in the no, it is Andhra Pradesh. It is Tamil Nadu. Andhra Pradesh. And let the matter appear on 18th of September 2025. Give your name, sir.
I've given, sir.
Your lordship would see the name. Tiruchanur Police Station, Andhra Pradesh.
Yadu.
Recorded in my lord's order to put the first line.
क्या बोला? Directed to take appropriate step for requisite for issuance of warrant upon the alleged contemners number 1, 2, and 4 through the superintendent of police as well as the officer in charge, Tiruchanur Police Station, Tirupati, Andhra Pradesh.
Your lordship kindly change the perception about at least me.
I am not keeping any perception. What is coming at the hearing of the case, what the court feels in the open court, the court is used to tell.
Observation about me is I don't.
Yes, call the matter. Fixed matter.
So your lordship takes up the fixed matter, my lord. Item number 9 is the new motion.
Item number
9 is the first new motion. Your lordship had heard me in part in GA1.
9.
Yes, my lord.
That one.
Yes, my lord. That so, my lord, that I was.
Come at 3.
3 p.m. That matter has been adjourned. I'll come at 3.
See, inform the other side.
My lord, Mr. Banerjee will be in difficulty at 3.
Okay, you
I will do my GA1.
You conclude it. 9 number ना 3 बजे होगा.
Till Mr. Dutt comes, my lord, may I start?
कल्याण आज बोल दो जो भी ऑर्डर है ना फटाफट टाइप होगा क्योंकि कल हम नहीं रहेगा इसलिए साइन होना चाहिए. नहीं कंटेनमेंट में कौन सा आज जो होगा ना कंटेंट में होगा. यस
Mr. Setia, and may I be? Mr. Setia, you had on the last occasion failed to recall as to how many companies you were connected with since you started the business. You. Today, are you in a position to give any other names except for RK Agencies and Ratan Enterprises?
Well, those two companies are companies with which I am currently associated. Throughout my life and career, I have been associated with many companies. You asked me specifically about companies in England. I recall the name of 4 companies in England with which I was associated as a director in the 1990s, to the best of my recollection. During the 1990s, to the best of my recollection. These companies are Haygreen Associates Limited, Pencharm Limited, Newbie Enterprises Limited, and Shasa Investments Limited. There are no records, so this is from my memory. And these were during the 1990s.
These were during the
90s.
Now, in these companies, were you involved as a shareholder or as a director?
Both.
Now, are there any other companies in which you have a shareholding?
I'm sorry, I didn't understand the question.
Apart from these companies, are there any companies in which you hold shares?
Today,
Yes.
not, I mean, I hold shares in Reliance, but that doesn't, I'm sure that's not the meaning of your question.
Okay, I hold share. Relax. That's it.
I hold shares in Reliance as on today.
Now, your father was just I'm sorry. Logic is no more. Your father, Ranjit Singh Sethia, was also a businessman. Am I correct?
He was.
And
Not by submit.
was he the only son?
No.
How many brothers and sisters did he have?
He had 3 brothers and 2 sisters. 3 brothers and 2 sisters.
Could you please give the names of the brothers and sisters of your father, Ranjit Singh Sethia?
His older brother was the late Umrao Singh Sethia. My father was the next child. Nirmal Kumar Sethia was his younger brother. Mrs. Well, not Mrs. because she took sannyas. So we just called her Guruma, was his sister, one sister.
Sister, Guru Maharaj. You said 3 brothers?
3 brothers, 2 sisters.
So,
Umrao Singh Sethia.
Now, what is the other 3 brother?
I'm finished. I'm still working through the list. The younger.
Oh, I'm sorry.
The youngest brother was Rajinder Singh Sethia. And the youngest sister was Mrs. Snehalata Dada.
Dada.
D-A-D-H-A.
And all of them were carrying on businesses, or they were professionals also?
No, I mean the sisters were married or sannyas. The Umrao Singh Sethia lived in India, and I'm not sure what he was doing, but he passed away. The other 2 brothers, Nirmal and Rajinder, were carrying on businesses in London.
And what about your father? Did he have any business in London?
Yes, as I said earlier, he was a director and a shareholder of House of Sethia Limited, along with various other relations.
By various relations, along with various other relations, what do you mean?
So, my family has been in business in London and Calcutta for almost 100 years, since 1927. My father was born in London. There was a joint family business. At the time in question, my father's brothers, Rajendra and Nirmal, had left the joint family business some years ago, and his father's cousin, Indra Kumar Sethia, and my father's cousin, Sampat Kumar Sethia, and my father remained in charge of the House of Sethia Limited and their group of companies.
When you say joint family business, whom would you say constituted that joint family at that point of time?
The business was set up in the 1920s by my great-grandfather and his brother. So the descendants, or some of the descendants of these two persons, remained in charge of the joint business in the 1980s.
So, in the 1980s, prior to Rajendra and Ranjit, prior to Ranjit leaving the joint family business,
prior to Rajendra
leaving the joint family business, they were all in control and management of the joint family businesses. Am I right?
No, you're not right, because Rajendra and Nirmal left the joint family business in the 70s.
Rajendra and Nirmal left the joint
family
business
in the 70s. And since then, your father or you have had no business connections with them. Is that your considered evidence?
Yes, I mean, I have borrowed money from my uncle from time to time. But I would not call that a business connection.
Yes, of course.
I would not call that a business connection.
Oh. Yes. Would you be in a position to tell my lord as to which were the companies in which Your father, Ranjit Kumar Sethia, was a director or a majority shareholder along with other family members.
May I refer to a couple of documents, please? There is the audited accounts of House of Sethia Limited. House of Sethia Limited, which is in the additional judge's brief of documents, in the second additional.
To see it,
Yes, please.
let the witness want this. I think it be volume 1, pages last four.
No, it's second additional judge's brief of documents.
Second additional judge's brief.
At the beginning, I think. Yes.
Maybe 2. Goes further. JB wanted. अरे JB wanted. JB want तो अपने काছে.
On page 18.
Just. Yes.
On page 18 and 19.
Oh.
There is a long list of all the companies that were associated or part of House of Sethia Limited. Also, there is another document, which is a document that was submitted by the bank in the proceedings in the Supreme Court. It was a search of SL Sethia Liners Limited. It lists the names of the directors of SL Sethia Liners Limited. It may be in the first judge's brief of documents.
Would you like to have a look at it?
Yes, please.
Please give it. JB1.
And it lists also the other directorships held by the directors of SL Sethia Liners Limited. So you would find from there the names of other companies where my father was also a director. Let me find the...
You look exhibit page. The exhibit numbers.
Page 126 to 143 of the judge's brief of documents. Ah, yes. On page 135, the other directorships of my father and his fellow directors is listed.
Page 136 of 135. Would it be 135?
Yes, 135.
135. Hey, help করে ওই প্রথমটা যেটা additional দেখালি ওটা exhibit কত? এটা So, Millard, let it be recorded that the witness has referred to 2 documents. One is DD
Recorded, no?
87. DD 87. DD 87, pages 1 to 22 of the second additional judge's brief of documents. And page 135 of
JBD volume 1.
DD 33.
DD 33, volume 1.
Nikha? Recorded?
135 take. 135 is part of a part of it.
135 being the part of DD.
DD, bolo. DD 33.
DD 33. Yes.
Now, you have referred to certain businesses carried on by your father's brothers in London. Do I take it that all these businesses were being run from London, having its registered office at 107 Gray's Inn, London, WC1?
No, that would be completely wrong.
Okay.
Um,
Please correct me.
Mr. Nirmal Sethia had his office at St. John's Street.
St. John's Street.
And Mr. Rajinder Sethia had his office at Bedford Row.
And who were in control of the companies which had their registered offices at 107 Gray's in London?
The three Sethias, Ranjit, Indra, and Sampath. Indra was the chairman.
And
Equally,
I'm taxing your
in
memory.
equal measure.
Could you give me the names of the companies which had? I'm sorry, I'm taxing your memory, but names of the companies which had their registered office at 107 Gray's Inn.
Can you give the name of the company
I
which
just
was situated at 107
Grazing Road.
Grazing Road?
I just gave the reference for a long list. It was about 20 companies. I do not know exactly whether all of the companies had their registered office at 107 Gray's Inn Road, but they may have. I mean, there were some international subsidiaries in France and America. They may have had separate registered offices.
But SL City Liners had its office at 107 Gray's in London. Am I right?
Correct.
So did Rumplace.
Correct.
Have you come across a name called ESAL Group of Companies?
That's ESAL, just for their benefit.
Yes, I have.
Yeah.
What were the, are you in a position to say as to how many companies were under this group of companies and what are their names?
The plaintiff should be in a position to say that better than I. I had nothing to do with those companies. They banked with the plaintiff.
Are you Do I take it that it is your evidence that you don't want to say or you don't know?
I don't know.
So if you don't know, how do you know that the plaintiff would be in a better position?
I know that they banked with the Central Bank of India. It was, and I know the name of the flagship company. I know the name of the flagship company, which is ESAL Commodities Limited. I don't know much else about their operations.
Anything more?
I have seen references in the witness evidence of Mr. Chopra in a criminal proceedings in Delhi, where there are references to other companies of the ESAL group of companies. And in Zaiwala's letters, which the plaintiff has submitted as evidence, but of which the plaintiff professes to know nothing, there is also reference to ESAL group of companies and some of its associates or subsidiaries or whatever.
Finished?
I finished.
When you say I, you only mean your personal knowledge. Am I right?
That's what I would mean, yes.
So, would you be in a position to deny if I say that your father, Ranjit Kumar Sethia,
Ranjit Singh Sethia.
Ranjit, I'm sorry, I stand corrected. My apologies. Ranjit Singh Sethia had proper business connections with SL Group, SL Group.
I believe that is not correct. They may have had trade relations with each other at arm's length, but they had no.
Do you realize that by referring to SL Group and House of Sethias, we are talking of two brothers, Ranjit Singh Sethia, one and Rajendra Singh Sethia on the other, and Nirmal Singh Sethia.
Three brothers.
Three brothers. Do you realize that?
They were, it was, sorry, can I start again? It was quite well covered, even in the media at the time, that three brothers with separate independent businesses were doing so roaringly well in the early 1980s.
Absolutely correct. Absolutely correct.
That's it. They had separate independent businesses, if that is the meaning of your question.
Last কথাটা লিখবেন তো। They had separate, if that is what is.
That is the meaning of the. That is.
But you won't. আচ্ছা আমি প্রশ্নটা কি করেছিলাম who are the name of the companies তার আগে একটা করেছিলাম which constitute না তার আগে এরকম জিজ্ঞেস করেছিলাম এসএল গ্রুপের কোন কোন কোম্পানি
As, sorry, may I add to that?
please
As a matter of fact, I remember reading that whereas Indra had managed to bring Ranjit into the business when he moved from India to London, he was unable to keep Nirmal and Rajender in the business.
When you mean SL group of companies, does it mean various companies under one head?
As I said, I don't know very much about the structure of ESAL group of companies.
Structure of the ESAL.
ESAL. I must add that in 38 years of litigation with the bank, no case has been made out that RK Agencies Limited was responsible for the alleged debts of ESAL group of companies. In fact, it is only now, 38 years later, that the bank is suddenly bringing up ESAL group of companies.
So, if I suggest to you that no, control. So, I take it that you are not in a position to disclose the names of the companies which formed SL group of companies.
Yes, I am not in a position.
So you will not also be in a position to tell my lord or inform this court as to whether Rajendra Singh Sethia was anyway involved with any of these companies.
Any of which companies? I'm sorry, I didn't understand.
Companies under the SL group of companies. But companies constituting SL group of companies.
Well, ESAL Commodities Limited was a company, and Rajender Singh Sethia was a director of that company.
So there you come with one name. What are the others?
Babulal Bengani was another director.
Okay.
At my time in London, there were other directors such as Ashish Banerjee in his companies. I don't know which companies. Rajinder Bhutoria, Fahim Naseem. These are people I have met.
These are people I have
met. When you say, sorry, anything more?
There must have been other people I met socially, but
when you say at my time in London,
just a minute.
I'm sorry.
Must have been other people I have met socially.
When you, I got you.
Yes,
when
yes.
you say at my time in London, which period are you referring to?
I lived in London from 1974 until 1998.
Okay. Was SL Setia Liners a customer of Central Bank of India London branch?
Yes, I believe so.
Do you have any knowledge of the disputes that arose between your father's brother, youngest brother, Rajendra Singh Setia, and the Central Bank of India in the year 1983 or 84?
I have studied it.
Studied. How old were you at that point of time?
I have studied it lately, not at that time.
Lately, not at that time.
At that time, I was 20 years old.
And by your earlier deposition, you have already started a trading business in some companies from London itself.
In 1990s.
Yes.
90s.
So you won't have any personal knowledge apart from whatever you have studied.
I lived there. I met my uncle. I have been to his office, but I was not involved in his business. So I knew he was doing very well. I went to business functions, parties, but nothing that would give me any special knowledge.
Can you say anything about whether your father was in any way aware of it?
He would have been more aware of it than me. I was at university at the time.
I was in university at that point of time.
Is it a fact that the ESAL group of companies, apart from businesses in London, had businesses in Nigeria, Zambia, and Sudan?
They had businesses all over Africa, in particular in Nigeria. I know that. I have been to Lagos myself.
Lagos myself.
Have you come across a name, Tush Ross and Company?
Yes. They are.
Tell my lord. Yes, sorry.
They are a well-known firm of accountants and consultants, and I think liquidators, if I'm not mistaken.
Now, would you be in a position to deny that it is these auditors who also were appointed as auditors of Central Bank of India London branch?
I cannot confirm or deny it.
Would you be in a position to deny if I say that Tush, Ross and Company was the auditor firm which for the first time brought it on record that Rajendra Setia and Ranjit Setia have taken huge amount of business loans from Central Bank of India London branch without giving proper security for the same, and that they were acting in collusion with the then bank manager of Central Bank of London.
I am objecting to this. It's a rolled up question. If Mr. Dutt can break it up.
Break it up. Second,
I would just like to answer it in one word.
Yes, he's giving the answer.
I'm giving the answer. It's a lie.
Huh?
It's a lie.
It's a lie.
It is not correct.
It's a lie. So, what according to you is the correct version?
May I refer to Mr. Chopra's testimony,
You can refer to anything.
which is in the second additional book of
Second judge's addition document. Second है?
Before I do that, I would like to refer to Zaiwala's letter also.
Before that, I also required to refer
Can I have
Daiwala's
the first-
letter.
And by the way, when I say it is a lie, I'm addressing them. I do not know what Tush Ross has or has not said, but the statement that you said was not correct.
Witness volunteers.
That's why I said correct me.
Right.
Our confidence is time.
Well,
our confidence is time. Shumamada
এটা বললো
Rajwala puch.
Yes, PD7.
Witness
Sorry.
refer. Page number?
Page number 14.
40.
Of JB?
14 of?
The first volume.
14 of volume 1
Page 40, volume 1.
of the judge's brief of document. 1-4.
Zaiwala and Company has written to the bank in responding to their suit. And they have written that our clients consider that if these wrong debits to them are rectified by the bank, their account with the bank will be in credit.
Credit. Double inflated. Our যেখানে our বলেছে
Yes.
That's it.
double inflated.
কি করছি?
So that is one piece of evidence.
Take the line from here, so I told him to put in double.
Invited commas. Witness reads kore debe na? Witness reads. Anything else?
Yes. The Central Bureau of Investigation went to London and investigated transactions of ESAL Commodities Limited. A trial took place and Mr. Chopra of the bank gave evidence. In his evidence, Mr. Chopra explained that the alleged advance to S.L. Sethia Liners Limited of US dollars 1,145,800 in July 1982 was not an advance to S.L. Sethia Liners Limited at all. It was an advance given to ESAL Commodities Limited by the bank against documents supplied by ESAL Commodities Limited, and the principal amount was repaid by debiting the account of ESAL Commodities Limited through the account of S.L. Sethia Liners Limited. This was done by the bank without the knowledge or collusion of S.L. Sethia Liners Limited or collusion of S.L. Sethia Liners Limited. The bank did it in this way in order to conceal the scale of its lending to ESAL Commodities Limited. It's also mentioned in the very first affidavit, volume 2, please, filed by the bank in 1987. Can I have volume 2? On page 173.
Witness refer, page 173.
Exhibit 3/2. On page 174, paragraph 5, Latin 1, small 1.
Roman 1,
yes. The bank has also testified about this transaction. Confirms what Mr. Chopra has said, but it hides more than it says. It does not mention ESAL Commodities Limited. It is written here. Shall I just give the whole passage?
Yes.
I'll read it out, but you can.
Yes, you read it.
Yes. Yes.
Witness reads the para.
5 Roman 1.
5 Roman 1.
The London branch of Central Bank of India has made an advance of US dollars 1.145 million against a bill for the same amount in July 1982 to S.L. Sethia Liners Limited. The said bill was, however, not paid on the due date. The said bill carried interest. Subsequently, the principal amount was paid and/or was adjusted but no interest that had become due on the said advance was ever received by the London branch of the defendant bank, and as such remained unpaid. So that is the substance, I think, of the claim of the London branch against SL Setia Liners Limited. It still has nothing to do with RK Agencies Limited.
So, Mr. Dutt, just a minute. Yes.
So, are you trying to say or depose before this tribunal? Sorry, yeah. This is what happens when you do too much of arbitrations. That though Ranjit Singh Sethia, your father, was a common director in RK Agencies as well as SL Sethia Liners.
He was not a director in RK Agencies.
RK Agencies was director? Oh, yes, correct. SL Sethia Liners. It had no connection with RK Agencies per se.
I am saying that SL Setia Liners Limited had no connection with RK Agencies Limited. With RK Agencies Limited.
Now, kindly come to, don't come. It doesn't have anything per se. I'm sorry. Who is Shanti Devi Setia?
Shanta Devi Setia
Shanta Devi Setia
is my mother.
Mother. Is it correct that she was a majority shareholder in RK Agencies Limited?
I think it is correct. When the company was formed, my mother's money was invested in the company, and since I was her only minor son at the time, the shareholders were my mother and myself as a minor.
Okay. And who was the shareholder of Range Commercial Private Limited?
I have no idea.
No idea.
It's a dead. You see, today, RK Agencies Limited is a private limited company. Until 2010, it was a public limited company. So it was necessary to maintain 7 shareholders, even if it was a closely held public limited company.
So all it boils down to this is that your father, who was a director in SL Setia Liners, possibly also controlled RK Agencies through the shareholding of your mother.
I am not going to confirm or deny that, but I would add that my father did not own or control SL Setia Liners Limited. Indra Setia and Sampat Setia outvoted him on the board and in the shareholding register of SL Setia Liners of House of Setia Limited. And they had nothing whatsoever, no indirect connection even with RK Agencies Limited.
On the last, I need to go to the next topic, but it's 11:30. Do I continue or come back tomorrow?
It is fixed tomorrow.
Yes, it's fixed tomorrow as well as day after.
Don't think it will be. Where from you came?
Sorry?
Pune.
I came, I was going to come on Saturday, but I came about 10 days ago
No, no,
from Pune.
he is from Pune, Millard,
Pune.
and considering that only my lord's desire was
That's
that
tomorrow, day after tomorrow, it not be possible.
then we'll come back another day. No problem.
It will not be.
No problem.
Because, my lord, last time also, you had fixed 3 days, but we had 2 out of 3. I don't know what the reason is.
Honorable judge will not be there. The court
Okay.
is there.
Oh, I see.
No, Millard. So that is there.
এখন তুমি ডেট নয় বলে দিয়েছি
ও ভাবছে তাই তো, ওই জন্য
Witness is present. Defendant witness is present. Cross-examination resumed. But due to paucity of time, cross-examination could not be completed. According clause is deferred. It is fine. So,
If an early date can be given.
one day at least, 2 days before, Millard.
I don't think
Kindly see the litigation your lordship has seen.
No, that's why fixing.
I'll take some time. I'm.
No, that's why fixing day to day. But what can be done?
I know. No, Millard. We are not. But kindly keep it after vacation.
First में कब first time मिलेगा देखो 2-3 डेट 2-3 डेट हाँ हाँ देखो third
11:30 করুক 12:30 করুক
third, fourth and sixth. Third, fourth and sixth November.
খুলছে কবে এই কোর্ট কবে খুলছে ডায়েরিতে না নাই ক্যালেন্ডার দিয়ে Mr. That can do 2 days at least before. Hey, today only he could have this guy habit of making me work.
No, I can fix, but there is my direct.
No, Millard.
Not permit before the vacation. All are fixed. Otherwise, I could the court of.
This is the first day of the reopening.
No, first is 27. First is the 27 October. So I am fixing.
So that is not even considering that. Nothing in October.
Okay, October देखो उससे आगे देखो
Millard.
10, 11, 12 देखो
10, 11, 12 any
10, 11, 12 है
September. अरे क्यों चुप कर
कब है सितंबर अक्टूबर नवंबर में 10, 11, 12
হ্যাঁ দাদা এটা তো
10, 11, 12
কাল পরশু তো করতেই
নেপালে এরকম করে দেখাচ্ছি দেখো
कितना बजे 2 बजे नहीं है 2 बजे है
डायरी
10, 11, 12 तीनों दिन फ्री है देखो 11:30 फ्री है 11:30 तीनों दिन on 10, 11 and 12 November at 11:30.
এই যে বললো বাঁচা গেল তো ঠিক আসবে
The hearing of this case on 26 and 27 is adjourned.
আমাকে পড়তে দে গেলাম
ठीक है उसको पेन ऊपर आएगा देन फिक्स हो आएगा पेन ऊपर आएगा यस थैंक यू नेक्स्ट कॉल
Lordships, I appear for the plaintiffs. Mr. Saha was leading me. He has already concluded his arguments in our injunction application.
I am led by Mr. Probal Mukherjee, my lord. He is in courtroom number 29, my lord. If you lordship give a short pass over, my lord, he will be entertaining your lordship.
Okay, pass on.
Great.
Next. Call the regular list.
Present. Present. Lordship, this is a suit for recovery of dues against goods sold and delivered by the plaintiff to the defendant. I'm praying for leave under clause 12. As part cause of action has arisen within the jurisdiction of this honorable court and part cause of action has arisen outside. We have already participated in the mediation process. It has resulted in a non-starter report, which is annexed.
When the last when the last payment was made?
Yes, Lordship kindly takes the last annexure, which is volume 2, page 196.
196.
196. Annexure J.
Yes.
Ledger statement. It reflects the entire chain of transactions, Lordship. And Lordship will see that page 199.
120. February 24.
Yes.
Not 29 February.
23rd of February 2024 was the last first check issued. Then there were a series of checks issued and returned. And the last actual receipt of bank transaction was 20th of January 2024. This is part payment against the total outstanding due.
Why the clause 12? Why the cause of
Plaintiff
action?
is within the jurisdiction of this honorable court and has his place of business here, but the defendant carries on business outside. However, the transaction meetings, the purchase orders were placed within jurisdiction at the office of the plaintiff's address, and the invoices were issued from here. The payments were received here.
Payment was
Bank
received Calcutta.
here.
The plaintiff has filed the present suit, praying for decree for a sum of rupees 47,76,153, along with interest at the rate of 24% per annum. The counsel for the plaintiff submitted. Plaintiff has initiated pre-mediation process, but was ended in failure. Accordingly, the plaintiff has filed the present suit. She submits that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court, and the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. Accordingly, she prays for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the plaintiff is within the jurisdiction of this court and the defendant is outside jurisdiction of this court, and part cause of action arose within the jurisdiction and part cause of action arose outside the jurisdiction of the court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted, subject to scrutiny by the department.
I'm grateful.
Yes, next.
So item number 6, I'm appearing for the plaintiff. This is also a suit for recovery against goods sold and delivered.
Same party?
No, not the same party.
Yes.
Lordship, the mediation has failed and resulted in a non-starter report. And Lordship, the last cause of action, Lordship will find again in volume 2 at page 165. Lordship has it?
Number 2022.
Yes, 15th October 2022, the check was issued, which was returned thereafter, dishonored. And the suit was filed in August 2025. I'm praying for leave under clause 12.
The plaintiff has filed this present suit praying for a decree for a sum of rupees 48,49,302 along with interest at the rate of 9% per annum. The plaintiff submits that part cause of action arose within the jurisdiction of this court, part cause of action arose outside the jurisdiction of this court, and the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction. The plaintiff submits the plaintiff has initiated pre-mediation process before filing of the suit, but the same was ended in failure. Accordingly, she prays for leave under clause 12 of the latest patent. Had the learned counsel for the plaintiff peruse the materials on record, This court find that the plaintiff is within the jurisdiction of this court and the defendant is outside jurisdiction of this court, and part cause of action arose within the jurisdiction and part cause of action arose outside jurisdiction of this court. Considering the above, leave under clause 12 of the latest petition is granted. Plaintiff is admitted subject to scrutiny by the defendant.
I'm grateful.
Next.
Number 10. My lord, this is our application. My lords, Rajiv, on the last application, this is an application under Order 39, Rule 1 and 2, my lord. Remember, my lords, we are being led by Mr. S.N. Mukherjee and Mr. Ratnanko Banerjee, who are both on the legs presently in court number 37. May there be a passover in the matter? Or Lordship, on the last occasion, I think, Lordship, we had indicated we were relying upon certain advertisements which were floated with respect to the building in question. Lordship was of the opinion
Which one?
that this item.
Statesman. Yes.
Yeah, I mean, let
Paso. Have you served the copy?
I'm serving it in court.
Serve the copy. Come. Let they come. Paso. Next.
Number 11.
Nobody is there. Item 11. Not today. Ready? Call the fixed matter.
Well, I'm sorry.
No. Call the fixed matter.
Come to this. Look at the petitioners. Let the petitioners. Number 3 and 4.
My lord, item number 11, my lord, I beg to appear on behalf of the plaintiff, my lord.
No. Yes, that is over. Yes.
My lord. My lord, I was unable to, my lord, enter the online portal, my lord. I apologize, your lordship.
Okay. Yes.
Lordship will kindly take up our the supplementary affidavit that we have submitted before your Lordship, my lord.
Give the supplementary affidavit.
And my lord, the plaint, that would be most essential. The plaint first part. Lordship has taken intensive notes, my lord. But this is a matter, my lord, Lordship may kindly recollect. This is with regard to power of attorneys. My lord, Punalur Paper Mills is a public limited company. I represent the present management of Punalur Paper Mills. But there is no doubt about that. But the other side, they are representing Calm Industries, but by virtue of a power of attorney given in the name of Kunal Dalmia and another person. In the plaint, they have sought for an order. There has been admittedly cancellation of those power of attorneys. There were 2 power of attorneys, and the power of attorneys have been cancelled. On the basis of that, they have come up before your Lordship, my lord, with a suit. In the suit, they have made 2 prayers. Lordship would kindly take those prayers first of all.
149. CS 149.
Lordship.
What has happened to the appeal?
Appeal stay has been granted.
Yes.
Lordship will.
Appeal, your lordship is talking about the appeal from your lordship's order.
No.
Yes, but that
No.
in yes.
No. Lordship, what had fallen for me, your Lordship, was there were 3 appeals before the division bench. But that was in
That was from
connection.
Order 7, Rule 11.
But if
of the
Mr.
city
Shen is
matter.
submitting, then I cannot.
Okay.
Every time.
Okay.
I wanted to answer.
Okay, no. Okay.
My lord, there were originally 3 suits, but I'm going a different track then. There were originally 3
Okay, no,
suits.
leave aside, leave
No,
my
I'm
question.
just, Lordship had a query in mind. I must address that. There were 3 suits. One, the first suit filed by them, 2 thereafter by me. My lord, in the first suit, we had given a counterclaim. Counterclaim was rejected under Order 7, Rule 11.
Correct.
Our 2 suits were also rejected under Order 7, Rule 11. Against those, we preferred appeal. My lord, in the appeal, my lord, Justice Shobboshachi Bhattacharya in a division bench has stayed the further proceedings of their suit. And our suit will also come up for hearing in the appeal together before their lordships. My lord, it is in the list before Justice Showmanship. This is the present position. Now, my lord, kindly turns to the suit that they have filed before your lordship, my lord.
Yes.
My lord, kindly comes to the prayer that they have asked for. That is at page number 45. Prayer A, decree for delivery up and cancellation of the purported deed of revocation dated such and such, of the power of attorney dated such and such, upon adjudging the same to be void.
Yes.
Now they are asking that the power of attorney, the revocation of power of attorney should be declared void.
Yes.
But the next prayer, decree of perpetual injunction restraining the defendant from in any manner relying on the said purported deed of revocation dated 11th May 2021 of the power of attorney dated 21st November 2011 or from making any representation on the basis thereof or from purporting to cancel or revoke the power of attorney dated 15th May 2010 or from making any representation to such effect to any person or persons or entity, authority whatsoever. But this is the prayer. My lord, now the injunction that has been prayed for before your lordship, my lord, if lordship may kindly see what is the prayer there. But if that is allowed, it would tantamount to disposal of the suit. Final decree would be granted. Injunction application. Injunction application. Lordship is perusing the injunction application. Lordship kindly sees orders prayer C and prayer D. Prayer A also, my lord.
Yes, prayer A.
But if these are to be allowed at this present moment, nothing remains.
Yes.
But what is the purpose for filing the suit in spite of their?
Yes.
There being a suit filed by them pending before the City Civil Court at Calcutta, my lord, so that these things can be adjudged in piecemeal. But this honorable court will never come to know what is going on there. That court would never come to know what is going on here.
That's why the first question the court has asked what has happened.
Yes.
7-11.
But that has been stayed. Now, my lord, in order to maintain judicial, this is my first submission. In order to maintain judicial conformity, my lord, so that there are no diverging judicial decisions, my lord, but this court should wait for what is happening before the appeal court. This is my first submission. My lord, second submission, lordship would kindly consider, my lord, passing an order in this injunction proceedings would tantamount to final disposal of the suit, which is not recognized under the provisions of law.
Yes. Yes.
Lordship would now kindly peruse, my lord, the order passed by the division bench, my lord, where they had challenged the order passed by your lordship, my lord. That is the order passed by Justice I.P. Mukherjee, my lord, that your lordship has.
16th May 24.
Lordship, absolutely.
Yes.
Lordship will kindly consider this order once. The division bench order 16th May 2024.
Yes.
Lordship, I will take your lordship to this the second page of the order, my lord.
We are not interfering with the judgment.
But
at all
although
at this stage. Yes. We make it clear that despite stay of the suit, interim application can be proceeded.
but the order passed by this honorable court, my lord, that has not been set aside. My lord, all observations made here, my lord, those are there. My lord, it is only an observation by the appeal court that GA1 may proceed. The sentence in the impugned order that GA1 of 2021 is dismissed is stayed. But the observations that those have been made in my lord's order, those are also concerning GA1. It is not that the contents of GA1 has not been considered by this court at all. Lordship may kindly take this into consideration. Lordship had taken note of pendency of the suit before the city civil court, the orders passed therein. They had ample opportunity to present such application or move this matter before the city civil court, who is in session of the matter.
Mr. Sen, what would
But
It is
there,
not there. Where will I move it?
their
No,
suit is
Both his suits are not there in city civil
no,
court.
I am not on the city civil
No.
court here.
Yes.
As per this division bench,
Yes.
the court has not interfered and the appeal is pending. We don't know what would be the outcome.
absolutely.
Yes.
So, if at this stage, though I have to deal with, as per the order passed by the division bench, the court is binding on that. But what would be effective that if anything happen in that?
No, I'll answer that specifically.
But I have not
That,
finished.
no. I'm just answering the
No,
question.
I am putting because of this.
Absolutely. Absolutely.
But kindly see that application where your lordship passed the order, that was in the nature of the suit should not be heard. Stay of the suit.
Correct.
So your lordship felt that the suit should not be heard. Then we went to the division bench only with the observation that even if we raised an appeal that against the order, but we in the stay application our point was that GA1 cannot be stayed. Stay of the suit does not involve or imply stay of hearing of interlocutory application. That is what only the division bench has clarified. Even if your lordship's order is right on the point that the suit should not be heard, but the appeal court felt that nothing should prevent the hearing of the interlocutory application. That is the only thing which is the division. So that is why the interlocutory application has to be heard. So even if the appeal is there, appeal is from your lordship's order whereby
staying the proceeding.
Staying the entire suit.
Correct.
But interlocutory application is never barred. Suit will never come up for hearing. That is the appeal. The appeal court will decide whether the suit should be stayed or not.
But
suppose the appeal is allowed.
Pending the suit.
That is the principle. Well, Section 10 principle is
correct
that trial is stayed.
Correct.
But in the meantime, the interlocutory applications will proceed. Otherwise, what will happen? Where will the parties go? If and when imminent something happens.
Okay.
No, that is the point.
Okay. Thank you. Yes, continue, Mr.
Kindly permits Mr. Mukherjee.
Yes.
But on the last occasion, my lord, I have handed over a compilation of documents to your lordship. না তোমাদের দেওয়া হয়ে গেছে লাস্ট ডেটে না শর্ট নোটস এটা কম্পাইলেশন
नहीं हो या नहीं
এটা একটা supplementary affidavit করে দেওয়া হয়েছিল না?
Supplementary?
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 Yeah.
Yes, it
Yes.
is there.
Tell
It
us.
is there.
তুই আগে জজ সাহেবকে অর্ডারটা পড়িয়েছিস? হ্যাঁ, সাপ্লিমেন্টারি করে
দেখানো হয়নি যে
সাপ্লিমেন্টারি দিয়ে দেওয়া। But we'll kindly turn over to page 4. But all that I am not trying to impress upon your lordship, my learned friend is seeking an order, my lord, which is in effect will give them final relief. Now, my lord, the question here is that whether, my lord, my client has revoked, my lord, the power of attorney lawfully and whether the revocation can be held to be lawful or not. They want to, my lord, in the meantime, pending, my lord, the hearing of the suit or a decision on the suit, but they want to, my lord, act on the basis of the revoked power of attorney by way of an interlocutory application, which I am opposing. Now, my lord, the question hinges upon that whether, my lord, the power of attorney was coupled with interest or not, not 202 of the Contract Act. Now, my lord, I say that it was not coupled with interest because of the fact that the chronology of events will go to show that it was not coupled with interest, but it was, my lord, only for the purpose of, my lord, the collect the compensation payable by the state government in respect of the acquired property to my client, and therefore there was no provision for appropriation of the, my lord, the amount which they are supposed to get on behalf of my company. So this is, my lord, the broad aspect of the matter.
So as per your assumption, that is not coupled with interest.
That is
Only for the execution of some work.
Yes, on my behalf, they
Correct.
were appointed. My lord,
Is that
they
all?
are my agent. They are my agent. So, my lord, here, my lord, there is one agreement your lordship will find which is dated 15th of May 2010. That is, my lord, at paragraph 4, page 4, I have mentioned chronologically about, my lord, the documents which my lord will require.
Which you are referring?
But that
Supplementary affidavit.
that supplementary affidavit found by Mr. T.K. Sundaresan on 29 November 2024.
No, दूसरा है ये तो जून का है.
No, Mr. T.K. Sundaresan,
So, ठीक है,
29
सुंदरम,
November.
28 January, तो 8 June. 29th November.
My 29 November.
Yes. Yes.
Number the first is an agreement dated 15th of May 2010. Thereafter, the power of attorney dated 15th of May 2010.
Yes.
Then comes the deed of revocation dated 22nd November 2011 of the power of attorney dated 15th May 2010. Then comes another power of attorney dated 21st November 2011. And then comes the deed of revocation dated May 11, 2021 of the power of attorney dated November 21, 2011, subject matter of the suit. Now, Lord, your lordship will kindly turn over to the agreement, but I'll just take your lordship to the page 7 onwards.
Yes.
Now, Lord, this is the power of this is the agreement of 15th May 2010.
Correct.
But internal page 12, that under mentioned various legal proceedings and or litigation were pending by or behalf of Punalur, challenging the acquisition and or requisition of recovery of compensation, mean profit and other relief from the said property. Internal page 12.
Yes, got it.
Calcutta wholesaler such and such, my lord, the particulars have been written down, the writ petition particulars have been written down. Then, my lord, next page, the Lindsay has purchased the said property from Punalur by virtue of a registered conveyance of the year 2003.
Yes.
And the same on the understanding that Lindsay shall at all time be entitled to continue to prosecute and or defend or any of the said litigation and a procedure, and also to receive, realize, recover all compensation, mean profit, issues and profits on account and in respect of the portion of the said property which have been subject matter of the said litigation in the name of Punalur but at its own cost. D. The property, my lord, was sold in 2003 by virtue of a deed. This is an agreement subsequent to, my lord, the deed in 2010.
Correct.
So the agreement was necessitated, my lord, because of the pendency of the litigation and, my lord, the money that should come because of the litigation. In pursuance of the understanding as here before stated, Lindsay has so far been taking appropriate steps for realization of the compensation amount and mean profit, and also continuing to pursue and prosecute the said litigation and are proceeding thereunder in respect of the portions of the said property in the name of Punalur. In the name of Punalur, my client, but at its own cost.
So cost
At its the cost of the agent, I mean to say.
Correct.
At its own cost means not in the name of Punalur, but at its own cost
They
is
will
the
pay.
agent's cost. It's. Then, Lord, next page 14. Then, Lord, the clause number 2, next page, page 14.
Taking steps for realizing and recovery.
Lordship.
Correct.
And also for taking appropriate steps for realizing, recovering compensation amount, mean profit from the appropriate requisitioning authority and or acquisition, and the same in the name of Punalur.
Correct.
Then, Lord, the next clause is, Lord, same. Then, Lord, the question comes that in the agreement, clause 4. The Punalur hereby also agree and confirm that in case of realization of the amount towards compensation or mean profit or otherwise, with regard to the portion of the said property, the same shall exclusively belong to the Lindsay, and the Punalur shall not be entitled any right or claim or any nature thereto. This is a clause in the contract.
Yes.
Page 15, clause 8, clause 4. Then, Lord, they have agreed to a particular, Lord, the amount to be maintained in a bank, IndusInd Bank at clause 5. Then, Lord, the page 16, clause 6 is, Lord, the power of attorney. The Punalur hereby also agree to grant power of attorney in favor of said Lindsay and or nominees authorizing and or empowering them represent Punalur, and also to defend and or contest and or prosecute all or any litigation and a legal proceeding, and further to realize the amount of compensation money, mean profit and other amount, and to operate the said bank account for receiving, encashing and appropriating the compensation amount, mean profit and other amount, and further to sign, execute, affirm, verify, deliver paper documents to all do act matters and things in the name and on behalf and on account of Punalur.
Yes.
This is not very particularly stated here. The purpose of the power of attorney was not to operate the account on behalf of Punalur. Then, Lord, the others are not very necessary, Lord, as of now. ওই পাতা হয়ে গেছে। Then, Lord, page 22, Lord, the power of attorney.
Yes.
But then, Lord, the power of attorney dated 15th May 2010.
Yes.
Then, but kindly skip over to page 24. But about not after fourth line from top, and or realization of compensation on account and in respect of portion of the said property, and for the said purpose to do all acts, deeds, matters, and things as the said attorney or either of them shall think proper.
Yes.
I'll take your lordship's kind leave.
Then, but the next page, page 25, the power of attorney shall be irrevocable until and unless cancelled mutually by and between the appointer and the said Messrs. Lindsay Tower Private Limited in writing. Then 4, my lord, the Punalur reserves the right to cancel this power of attorney if any of the attorney acts beyond contrary to the spirit of this power of attorney. The right reserved at clause 4.
So 3 is irrevocable, but
my lord, it is qualified by clause 4. It is controlled by clause 4 rather.
okay.
Then my lord, the power of attorney was revoked at page 27. That is, my lord, the power of attorney which was, my lord, executed on 15th of May.
Yes.
And this was, my lord, the dates we have given in, my lord, the paragraphs, my lord, on which date, my lord, it was cancelled. But the reason was, therefore, the above power of attorney executed on 15th May is hereby cancelled and revoked today, that is on 22nd November 2011, in view of execution of another power of attorney on 21st November 2011. This is the reason of cancellation, because there was a lot of subrogation or a substitution by another power of attorney. So, then, Lord, at page 29.
Yes. This is another one.
Another, Lord, this is the power of attorney which was, Lord, followed.
Correct.
Then, Lord, kindly see the last, Lord, 3 lines. In connection with the land acquisition matter pertaining to premises situated at number 13 Lindsay Street, Kolkata 87, pending before the land acquisition authorities and respective appellate authority, including the appellate tribunal and all courts in India, on behalf of Punalur Paper Mills Limited.
Yes.
But this is 21st November 2011.
What was the necessity to revoke and execute this?
Another gentleman has been appointed. Here, Lord, that was in the name of Lord Kunal Dalmia. And Lord, this is in the name of Lord and Ronoj Rai Chaudhary, one Mr. Ronoj Rai Chaudhary. Yes. In the power of attorney executed on 15th May, there were not 4 persons who are appointed as the
Here only one
attorney.
Kunal has been given.
And Lord, Mr. Ronoj Rai Chaudhary too. This is in page 29.
Yes.
Your Lordship.
Earlier 4 persons, sir.
Earlier 4 persons.
Yes.
Hand over. Then, Lord, the deed of revocation comes, Lord, at page 31.
Yes.
But the second paragraph. And whereas with the authority vested on me by a board of resolution passed on 12th day of April 2021 by the board of directors of Punalur Paper Mills Limited, it has become necessary and expedient to revoke the power now known and by this deed I cancel the said power of attorney and absolutely and completely revoke also all powers and authority thereby and thereunder given to them, either expressly or impliedly, to all intent and purpose, provided that nothing herein contained shall render invalid or ineffective any act, deed, or things lawfully and bona fide done or caused to be done by the said attorney and by virtue of the power given to him before the revocation of this presence.
Yes.
And Lord, this is the revocation which is the subject matter of challenge.
Yes.
And Lord, the revocation is of the power of attorney which appears at page 27. I'm sorry, Lord, the power which appears at Lord,
29.
Page 29. Yes.
29, 30, the last.
The last. This is not the power of attorney.
Yes.
So, Lord, the question is, Lord, whether by this power of attorney, Lord, the right has been created or not. Lord, what has been stated is, Lord, at second paragraph of Lord, page 29.
Yes, for doing work.
Doing something in furtherance of and on behalf of Punalur.
Correct.
Not that you appropriate. Not that the interest is created on your behalf.
Yes.
Now, these are the German documents here. Now, your Lordship will kindly come to the order of the division bench at page 46, 47, 48 of the affidavit in reply of Mr. Ronoj Rai Chaudhary. একটা বার করতে পারবি রনোজ রায় চৌধুরী? Yes. Page.
Yes.
But this starts at page 25. This is an order on an injunction on an injunction application. Wherein in the question of the power cancellation of the power of attorney has been dealt with by the appeal court at page 46, 47, 48.
What about the third paragraph, 46?
The second, third.
It is this clearly established that the cancellation of power of attorney is prima facie illegal and it is an agency coupled with interest.
Even if one may be persuaded to ignore the other claims of KHM, the right that accrued in favor of KHM by reason of act done in pursuant of the power of attorney needs to be preserved. This is not an observation which they say. Because this is emanating from an order of injunction wherein a particular amount which is accrued by way of the compensation for acquisition, who will keep that or who will appropriate that. This was the major question. Then the next page 47, the KHM had in the meantime realized a sum of rupees 9 crores unearned on the basis of the order passed by the coordinate bench on 4th January such and such.
Yes.
It is undisputed that the power of attorney was revoked much later on 11th May 2021.
Yes.
And at that time, KHM was entitled to the said amount.
Yes.
A suit filed subsequently cannot deny the payment of such compensation amount without Punalur establishing their right to receive the said compensation amount on revocation of the power of attorney. However, the learned trial court did not permit the parties to utilize the compensation amount till the disposal of the suit. This is because the power of attorney it says that till it is revoked, whatever that has been done that stands ratified.
Yes.
So that's the reason the division bench says that it was before the revocation and therefore protected the right to receive of that amount by either of the parties after adjudication, with a view to hold the ring pending final adjudication. We permit KHM to retain and utilize the said amount upon furnishing security to the satisfaction of the learned trial court, insofar as the balance sum of rupees 9 crores deposited in connection with LA case number such and such were not inclined to direct the Registrar General to release the said amount at this stage on consideration of the decision of the Honorable Supreme Court in case of such and such. Since we are of the prima facie view that the cancellation of the power of attorney was illegal and the documents executed in favor of KHM are established a clear right to receive the compensation at this stage, we do not direct KHM to return the said sum to Punalur. Then others are not very necessary at the moment. This was an interim order which was passed by the division bench. I should have pointed out to your lordship about what was the observation. Do I continue or I come back tomorrow at 12:30?
Yes. If you want to continue 10 minutes, you can.
Now, my lord, your lordship will also, my lord, kindly take note of my lord's order. Lord,
How the order of the division bench will affect in this matter? Because the observation of the prime facie, whatever.
the orders passed on an interlocutory proceeding, Lord, it is not binding on Lord in the final stage of the proceeding that way, because that was a tentative finding based upon Lord what was brought and submitted before the court.
This is filed. This is passed in which matter?
But this was in a Lord suit emanating from Lord the city civil court. Lord, my learned friend will not better Lord because he was there. I find. Fatima chilo.
Yes, it is before the civil citizen. FMAT. FM and FMAT.
Yes.
Yeah, next.
Now, Lord, my lord, in my lord's order dated, Lord, 5th of Lord July 2023, it has extensively gone into Lord the question about Lord that was raised before your lordship.
Yes.
This was in connection with this matter which I am arguing before your lordship.
Yes. That you pointed out.
Yes, your lordship will kindly see, Lord, my lord's, your lordship has taken out, Lord, by excerpt, Lord, the prayers in, Lord, the plaint, the applications. Yes, I think what you ordered to be but না ওইভাবে তো বলতে পারবো না আমি
Yes.
Internal page 11, Lord, the Supreme Court order, the last paragraph is very important. This was not from the division bench order which I just read.
Yes.
That not it says that the trial court would determine the rights and pleas raised by the parties in accordance with the law and based upon the evidence laid by the parties. Although it is in connection with the trial court where Lord, there's 3 suits were pending at that point of time.
Yes.
Then, Lord, as against this order, Lord, I think I've handed over, Lord, this order of the division bench, which only, Lord,
16th May order.
16th May order
That
your lordship has, Lord, already. But may I come back tomorrow? Yes, Lord. Tomorrow I'll conclude, Lord, because
Tomorrow, I don't think the court will.
No, tomorrow it is fixed.
Tomorrow, but tomorrow and day after tomorrow, I will not be there.
Lordship, any other day, not the next day, Lord.
Counsel for the defendant, plaintiff has argued. Also, the defendant in the matter, respondent.
Lordship.
Yes. Counsel for the defendant has argued the matter at length in connection with GA1 of 2022. But due to paucity of time, hearing could 22 GA1 2022, but hearing could not be completed due to paucity of time. According case is adjourned, let the matter appear before vacation. कुछ है सितंबर में 11:30 कितना बजे कौन सा 22nd September or 22nd and 23rd September 11:30.
Lordship.
The hearing of this case on 26 and 27 is adjourned.
Can I take the liberty of, my lord, since your lordship is fixing date, there is another matter. Your lordship will remember Mr. Moinak Bose was arguing that Order 7, Rule 11.
Which one?
Manoj Kumar Gupta. It was fixed on 18th
of
September at I think 12 noon or 12:30. But I'm in some personal difficulty during that period. But if any other day, I will talk to Mr. Bose and I will give you lordship because I saw some date is still there. So that is why I took this opportunity. I'm great. Maybe at the time of rising today, I will
Mention that, we'll see to
Yes.
that.
oblige.
Thank you. वीक में देखो या 28, 29 ये फर्स्ट वीक में
29th I have some difficulty. I don't know whether 28th. 28th আছে ওটা? এক তারিখে? এক তারিখে?
हम्म
এক তারিখে আমার অসুবিধা নেই।
28 टॉप है ना एपी है ना तो वो वाला फिक्स है जिसमें सारा वो कौन सा 31st तो छुट्टी है एक 2-3 तारीख ठीक है
বাট সকালে এক সকালে না একে তো ভোডাফোন আর জিএসসি আছে আমার আগে জিএসসি টা চলবে ইট ডাজন্ট ম্যাটার সেকেন্ড
15 ठीक है सेकंड है ना हाँ कॉमन सेकंड
but is it possible on the third ballot either first or the third
already
third first half ballot if any time ballot possible or ballot 3 o'clock ballot is fixed at max ball I don't know whether 2 o'clock ballot wants to take
ठीक है third at the top in the new motion
After once Mr. Banerjee concludes, my lord, we'll make our submissions.
I'm so grateful much obliged I'm very good
yes call the fixed
Lordship, I appear for the plaintiff. My witness is ready.
Yes.
It's an undefended suit, Lordship.
repeat after
Yeah.
I
solemnly affirm
that
in
whatever
whatever
I will depose
I will depose
in this suit
as evidence,
I shall
I shall
speak the truth
speak the truth,
and no part of it
no part of it
shall be false,
shall be false.
and I shall not conceal anything.
Anything.
What is your name, sir?
My name is Satish Pujari.
Satish.
Yeah.
SATISH.
Pujari.
Pujari.
POOJARY.
POOJARY.
Yeah.
Father's name?
Vammaya Pujari. BOMMA YA. Pujari. Yeah.
Your age?
Age is 54.
Occupation?
Occupation service. Yeah. Yeah. I'm represented for Gemini Equipment Rental.
Residential address?
C45. G1 Pushpa Housing Society.
G1 Pushpa Housing
Society. NSS Road.
Dombivli
West.
Bombay.
Yeah, Bombay.
NSS Road.
Dombivli West. Dombivli. Yeah.
Dombivli West.
Mumbai. 421202.
421202.
What is your designation, Mr. Pujari?
My designation in Gemini Equipment Rental is General Manager Finance and Accounts.
Accounts. Finance and accounts.
Lordship, may I show this? What is this document, Mr. Pujari?
Yeah, this document is a board resolution passed by the board of. This is a board resolution passed by the board of director to authorize. To me to attend the court against Express Devgan. Yeah,
Proceedings.
against Express Devgan.
Devcon Private Limited.
Yeah.
Is this the original board resolution?
Yeah, this one is the original document.
Lordship, let it be marked as exhibit. Lordship, this is page number 124 of my list of documents. This board resolution copy is already
show an
there.
original copy of the
Page 124 of the list of
document
documents.
appearing in page 124 of the JBD.
Lordship, list of documents. Lordship, I have filed list of documents affirmed on. Affirmed on 9th November 24, Lordship. 9th November 24.
124 of the list of documents.
Lordship. Let the original be kept on
Exhibit A.
Lordship. Exhibit A.
Exhibit A.
Yes.
Exhibit A. Lordship, may I show him pages 9 to 13 of the list
Will
of
not
documents?
tender the examination.
Yes, Lordship, I will show the documents that I tender. This board resolution tendered, Lordship, it is marked exhibit.
Okay.
The other documents I am showing from the list of documents only.
Now, before the documents, you will not tender the affidavit of evidence.
Lordship, sorry. I apologize.
Hello.
Mr. Pujari, what is this document? Kindly tell my lord.
Yeah, this one is document is evidence of affidavit signed by myself.
Myself.
Kindly show that page number 21. Whose signature is appearing on this affidavit, Mr. Pujari?
Yeah, this signature is myself.
Who has prepared this document?
This documentation prepared by my advocate as per my guidelines.
Are the contents of this document true and correct?
Yes, correct.
Yes, now proceed.
Shown page 9 to 13 of the list of documents. Shown page 9 to 13 of the list of documents, Mr. Pujari.
Yeah.
Kindly tell my lord, what are these documents? Page 9 to 13.
Yeah, this the document pertaining to page number 9 to 13. Yeah, first one is dated 2nd January 2014. Page number 9, dated 2nd January 2014. This one is work order issued by Express Devcon Private Limited to Private Limited to supply of tower crane on for rental basis. Is a higher charges. Yeah, for the period of 8 months. Page number 10. Then page number 11 for dated 7th January 2014. 2nd January 2014. Yeah. This is extension work order. Further extension of work order. Then page number 12, dated 8/8/2016. Issued by Express Devcon Private Limited for extension of purchase order up to 31st December 2016. Correct?
Kindly specify page number 13.
Yeah. Page number 13, once again, this also amendment of work order dated.
Amendment of the work order.
This one is a rental period extended up to 31st July 2017.
Mr. Pujari, how have you received this work order and the extended work order?
Yeah, this all work order has issued through email communication.
Who has taken printout of these emails?
This all email communication taken by from my computer, myself only.
Are the contents of these work orders and the extended work orders true and correct?
Yeah, true. Yes, true.
Lordship, let it be tendered. I am tendering these documents.
Where is the 65B?
Lordship, I have prepared. May I file it, Lordship?
Okay, you have a
Yes, Lordship, I have it.
exhibit B collectively.
Mr. Pujari, kindly come to page numbers.
Just a minute.
14.
Just a minute. Just.
Lordship.
कल्याण उनको बोलो सील बना दो एग्जिबिट्स ए बी सी डी लिटिल बेटर yes
Mr. Pujari, kindly come to page numbers 14 to page number 76 of list of documents. 14 to 76. Kindly tell my lord what are these documents.
76.
Page 14 to 76
Yeah.
of list of documents.
Yeah, this all related to the rental charges issued against issued against Express Decon. And this all invoices are sent through email communication.
All invoices are sent to email communication.
Yeah, this all odd invoices total amount was odd 68 lakhs.
Whose signature is appearing in these invoices at the bottom? Kindly see page 14. Whose signatures
Yeah,
are appearing?
this one is myself only. Myself only.
How have you sent these invoices upon the defendant?
Already stated email.
Yeah, it's by email.
Are the contents of all these invoices true and correct?
Yes, this all true and correct.
Lordship, I am tendering these invoices.
See collectively.
Page number 14 to
14 to 76. Mr. Pujari, kindly come to page number 77 and 78 of the list of documents. Kindly tell my lord what are these documents. 77 and 78. 77 and 78.
78, na? This was email communication exchanged in between Gemini and Express Devcon. Gemini and Express Devcon. Page number 77 mentioning the to release of outstanding dues of 18 lakh odd figure.
and
Odd figure.
Can you please specify what is appearing in at page number 78?
70. This also pertaining same once again my credit control manager has sent email communication to release of outstanding payment of 18 lakhs.
What is the name of your credit control manager?
Deepak Court.
Are the contents of these emails?
Deepak Court. DEEPAK KHOT.
Are the contents of these two emails true and correct?
Yes, this all true and correct.
Who has received the printouts of these emails?
Printout myself only, this one done.
Chip, I am tendering.
Exhibit B, collective.
Mr. Pujari, kindly see page numbers 79 to 84 of that bundle of documents. 79 to 84 and kindly tell my lord what are these documents.
This is these email communication done between ourselves and Express Devcon. Page number 79, whereas you are mentioning to issue a gate pass to issue a gate pass to lift the material tower crane, and dated page number 80 dated October 26 2017. This also regarding gate pass, issue of gate pass. This all document related to release of gate pass.
Are the contents of these emails true and correct?
Yes, this all true. And
Who has taken printout of these emails?
this all taken by myself from my computer only.
Lordship, I am tendering these all emails together 79 to 84. There are 4 emails, Lordship.
Exhibit C.
Exhibit E.
E collective.
Kindly come to page 85 of the list of documents, Mr. Pujari, and kindly tell my lord what is this document. Page 85 of the list of documents.
85, 1 minute. Page number 85. This email received from Duraj Maitra, Gujarati, Thurjati, Maitra, Maitra. This regarding also gate pass, issue of gate pass. They are mentioning needful like this also gate pass only. Issue of gate pass.
Let it be damn tendering. Who has taken printout of this email?
This one is myself only taken
Are
the
the-
printout from my computer.
Are the contents of this email true and correct?
Yes, this is true and correct.
I'm tendering, lordship. Mr. Pujari, kindly come to page 86 of this bundle of document and kindly tell my lord what is this document.
Exhibit F. 86. Yeah, this email communication done from myself only to in this to Durajati Maitra. In this you are mentioning that one point number 1 is to release the payment of 15 odd lakh. Then second, the release of gate pass. Third one is if you are not releasing the payment, then you are liable to pay the damage charges of 50,000 per day. 50,000 per day, effective from the date.
Are the contents of this email true and correct?
Yes, it is true and correct.
Who has taken printout of this email?
This one myself only.
I'm tendering, lordship, this document.
Exhibit G.
Exhibit
G.
Kindly come to page 87 to page 90 of this bundle of document and kindly tell my lord what is this document.
This document number 20.
87 to 90.
87 to 97.
87 to 90.
This document is a legal notice sent by my advocate to release of outstanding dues of 15 lakhs odd figure and issue of gate pass. And this document signed by Sahil Shah is a representative of DSK Legal. DSK Legal. Is my advocate.
Are the contents of this document true and correct?
Yes, this is true and correct.
Did the defendant receive this letter?
Yes.
How can you say that the defendant received this letter?
There is a communication this one 87 to the deponent has sent a legal notice. Page number. Page number is a 91. 91 to 95. This this pertaining to the reply for the my notice issued by my lawyer DSK Legal. In this they are demanding of rupees 3,37,221 claim against against us.
Did you receive this letter dated 30th November 2017 at page 91 from the defendant?
Yes.
Are the contents of this letter dated 9th November 2017 and 30th November 2017 true and correct?
Yes, this is true.
Lordship, let it be tendered as they have received my letter and replied to my letter. Both these letters together be marked exhibit. Lordship. Page numbers 87 to
Exhibit F,
95.
H.
87 to
Page number 87 to 95.
Collectively, huh?
Two letters.
Collectively. Yes, next.
Mr. Pujari, kindly come to page 96 of the list of documents. Kindly tell my lord what is this document 96 and 97.
This email exchange between us and Express Devcon. Yeah. To release of my equipment.
Release of?
Release of tower crane. And also we sent a debit note towards withhold of assets amounting rupees 14,16,000.
Who has taken printout of these email?
Yeah, myself only taken the printout.
Are the contents of this email true and correct?
Yes.
And the debit note at page 97?
Yeah, this also signed by myself only.
Not yeah.
Yes. Sorry, yes.
I apologize, Lord. Lordship, let it be tendered 96 and 97.
I collective. Sorry,
Kindly come to page 98 of the list of documents and tell my lord what is this document, Mr. Pujari?
yeah, this document received from Express Devcon dated 27 February 2018. This one is lien against my outstanding to 3,37,221.
Are the contents of this letter true and correct?
Yes, this is true and
How was this letter sent to you?
by email.
Who has taken printout of this email?
Myself only.
Who has taken printout of this letter? Email
A letter.
Lordship, I am tendering this letter.
Exhibit J.
J. Mr. Pujari, kindly come to page 99 and 100 of this list of document and kindly tell my lord what is this document. 99 to 101.
This once again the communication done between us and Express Devcon to release of the tower crane for this one, especially for the issue of gate pass. Issue of gate pass.
Especially for issue of gate pass.
Who has who has taken printout of this email?
Yeah, myself only taken the printout.
Are the contents of these emails true and correct?
Yes, true and correct.
Lordship, I am tendering page 99, 100, 101.
Exhibit K.
K.
K. Collective.
Exhibit K.
K.
Yes.
Mr. Pujari, kindly come to page 102 of this list of documents. 102 to 104. Lordship, I am taking together 102 to page 123 of this bundle of documents. Kindly tell my lord what are these documents. 102 to 123.
The page number 102. This order against GA number 2895 of 20185 to appoint a receiver.
Kindly tell my lord what is the date of the order appearing at page number 102.
Date of order is 14th November 2018, issued by Judge Soman Sen.
Kindly tell at page number 102, order dated.
Yeah. Yeah. Yeah, its order date is 10th October 2018. Yeah.
Was any receiver appointed by this order?
Yes, received by.
Can you please name the receiver?
Yeah, 1 minute. Tushar something is there. Yeah, Tushar Sinha Mahapatra, advocate, as appointed by the court.
Kindly come to page 104. Kindly tell my lord what is this document?
Yeah, this one is a order against GA number 2895 to really the receiver to the complaints. The order date is this one. This one is a receiver circulate order on the receiver by the honorable court to circulate the report
Kindly tell my lord that
among the all the parties in the court of that day.
kindly tell my lord what is appearing at page number 105 to 123.
5 to 20. This page number 105 to
123.
123. This is a receiver's complete report. Receiver's report.
These are court order and the
Tushar issued by Tushar Sinha Mahapatra, advocate. As per court's order, as per court order.
How are these orders copy received? Are these certified copy? What are these copies? These two orders copy at page 102 and 103? Sorry, 102 and 104?
102 and
what are these orders copy?
This receiver copy actually. Yes, but they can court is this one.
Are these certified copy? May I
No,
explain?
this-
Or a server
Why
copy?
you persons are bringing the set order copy by exhibit?
Lordship, for the reason, Lordship, this is I am claiming
What the
damages.
reason? If
It
you
is
are
not
relying upon
required.
the on order, then you can at the time argument you can place the
Yes,
order.
Lordship,
Why?
I
How
can.
the witness can clarify who passed the order, which date
Lordship,
the
not
order is
required.
passed?
I just wanted to put it as exhibit. These
If it
order
is,
and the
if it is
certificate
other
report.
court's order, you want to rely, then it the certified copy will go. But the same court order, it is not
Lordship,
required.
These are server copies, Lordship. Both are let it be exhibited, Lordship. Server copy and the report.
Yes. Next question.
These are all, Lordship.
That's all.
I will come to other things.
But with regard to the how the report, this is a certified copy of the report.
This is the report of the receiver is, Lordship, original copy which the receiver has circulated me. I am holding that original copy, Lordship. Though it is marked, Lordship. The receiver
Original
has
copy that
circulated
is
the
to be
copy.
exhibited.
Yes, Lordship. Let it be exhibited. I have brought the original copy.
Where is the
But I have
original?
marked.
How you got the original?
It was communicated. Justice Shuman's in order is there that you communicate. The receiver is directed to communicate the report. This is the original copy. The receiver has communicated, the learned advocate.
But you marked in the original.
Yes, Lordship.
How it
I
will be
apologize,
exhibited?
Lordship. Photocopy, Lordship, I have filed. It may be considered at the time of argument, but Lordship, this is very important for the reason.
That's correct. That's why important. That's why if you're relying upon the, then you have to either you have to bring the original of the report in which either it is in the GA 2895.
Lordship, in GA, this matter, this is the original. Like, kindly see the
But you
signature
have
of
marked how it will be exhibited. You have tempered the original. How it will be exhibited?
photocopy. Lordship, this is
No.
an admitted document. Then it is not required, Lordship. It is court record. From the order sheet, it will appear.
Show me where is the court record.
Lordship would see the
Your
order.
original side has adopted in new rules. All the GA will go to the Bay of Bengal.
Lordship,
After the disposal, where you get the GA order and GA report.
Lordship, Justice Somen's order says that the receiver.
That's correct. Or
Lordship,
that's
that is all.
order is not. Where
That is all.
the report you have to prove. Mere exhibiting the report will not prove.
Then the receiver has to be brought,
I
Lordship.
don't know.
Then I
The
will
court
take.
will not advise you. And how the report, if you are not having the report, how the receiver will come and say, what step you have to take for exhibiting the document?
Lordship would see Justice Somen's order.
And I 110% agreed the justice, whoever the judge has passed an order, there is an order. There is a report. But the mere bringing the report on record will not say that the report is proved. Report is to be proved by the person who has prepared. Who has prepared, he has to examine or whatever it is. There is a procedure for bringing the report on record and exhibiting the report.
I shall
How
do
you
that
can
on
say?
the next day, Lordship, after this
How you
witness.
bring the original?
Lordship, for that, let this witness examination be concluded.
I will, but that will not be exhibited.
It will be
General
exhibited
copy
by the receiver, Lordship. The receiver who was appointed, he will bring the original report, and at that
He will
stage,
bring the original report.
Sir, Lordship, summons would be served upon the receiver.
Madam, you can summon. Receiver will come, but the receiver has not kept the original report with
Lordship,
him.
in my most respectful, humble submission, it must be filing in the record, GA. It must have been filed because the order says that the receiver's report is filed in court. Let it be circulated between the parties.
In which case it in which proceeding the receiver was appointed?
GA number in this
So
proceeding.
J is here.
9 of 2018.
J is continuing in the CS.
Lordship, then I shall file before the department. I will request the department to produce the record of GA 2895 of.
That's what I'm telling. First,
Lordship.
yes.
Lordship.
What is the concern? Continue.
Yes, Lordship.
Leave aside on the leave that question. This is the order.
Lordship, now may I show him
The order passed by this court in GA number 2598
of 2018.
of 2018 dated. What are the dates?
10th October 2018 and 14 November 2018.
10th October 2018 and 14 November 2018.
2018.
Yes. Next.
Shown copy of the plaint. Act to plainted copy. What is your prayer in the suit? What is your prayer before my lord? Let him answer that question and you can go to the plaint. What is your prayer in the plaint?
Yeah, we requesting to release the entire amount of odd 68 odd figure. Out of this base rental around 15 lakh and 22 lakhs odd amount was pertaining to damage and damage.
Pertaining to damage.
Pertaining to damage and 29 lakhs this also pertaining to withhold of assets. That's why we are charging additional damage charges also.
68 lakhs.
Yeah, 68 odd figure.
68 lakhs.
Shown page 22 of the plan.
Yes.
Signature is appearing at this page, Mr. Pujari, at page 22 of the plan.
Yeah, this page number 22. This was Palas Chaturaj.
Chattaraj,
Chattaraj, whereas he is service engineering for that specified site. Yeah.
He was the service engineer of the plaintiff company at the relevant point of time at the site.
Right.
I'm grateful, Akshay. Are the contents of this plan true and correct?
Yeah, true and correct. Yes, true and correct.
Who has prepared this plan?
Yeah, this one is done by my advocate from as per my guidelines.
Are the contents of this plan true and correct?
Yes, correct.
Lordship, now may I show this, Sir Lordship, that affidavit 65 please?
Yeah, show me the first name. Madam, this is not the way of the 65. You have to explain each and every documents.
Lordship, I have given in nutshell. I have not given details of the invoices because, Lordship, for all the documents here are through emails, Lordship, with the
Correct.
work order invoices. So I've written, Lordship, in paragraph 3 to certify that all the work orders, invoices, letters, email exchange between the parties as produced in the instant matter were downloaded. Lordship, here all the documents are exchanged through email.
That's correct.
That is the reason.
But go to the 65, now the 60, now which year matter? CS Com
24, Lordship.
2018. You go to the 65, you have to explain this is the email dated so and so, download, and then only it will be exhibited. All on the last occasion also I find some of the advocates are the same. In the general
Subject to
affidavit of
correction,
65 will, if it is
Yes, Lordship.
contested, your total document will go.
Lordship, subject to correction, I have asked the witness how he has taken printout of those
That is
emails.
different thing. We have to affirm in affidavit under 60. You go through the
Yes, Lordship,
65,
may I
give
do
the
that?
evidence set.
Yes, sir, Lordship. I should have done that, Lordship. My mistake.
And the
Lordship.
Supreme Court has fixed the guidelines how the electronic document is to be proved.
Lordship.
Yes. See how many conditions.
Can you read? Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the condition mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in proceedings without further proof or production of the original as evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. The condition referred to in subsection 1 in respect of a computer output shall be in the following, namely, the computer output containing the information was produced by the computer during the period over which the computer was used
साक्ष्य
regularly.
अधिनियम काय
During the said period,
भारतीय साक्ष्य अधिनियम
the Lordship, though details are not given, but Lordship, it is there. It in a nutshell, Lordship, it has been stated that all the emails, work order, letters are taken by me from my computer. I have taken the printout and I'm certifying to
the
that.
third one यहाँ का तीसरा बुक कहाँ गया साक्ष्य अधिनियम now in the amended भारतीय साक्ष्य अधिनियम conditions has been prescribed. You have to prove that I think 5 or 7 conditions are there. Where is that? That is 63. In the 65, now it has come 63.
Lordship, subject to correction, I have read that also. Presently, it is not with me, but there is no changes so
अरे
far
वो नहीं
65B is concerned
इस
in
तरह
Sanita Act, Lordship, subject to correction.
इस तरह बुक और एक बुक हो
It is as it is
हाँ चलेगी
65B.
मंगाया था इसमें नहीं है
This particular section, Lordship, there has been no amendment. Subject to correction, Lordship.
Yes, there's a conditions. So, what do you do?
Then, Lordship, I take your Lordship leave to file that affidavit again, Lordship. Let it be kept on record. I shall
Yes,
file that
keep
affidavit.
it. You file separate affidavit disclosing the contents of the document.
Lordship, I shall do that. Lordship, then I have to bring my witness again, or Lordship, I have to bring my witness again, Lordship. I shall do that.
No, not necessary. Only affidavit you can file.
May I
Witness
file
is not-
supplementary affidavit?
You
to
file the
Lordship?
separate affidavit under 65B that will be taken on record.
Lordship.
You put it.
To the question. Mr. Pujari, what is this document? What is this document?
This document affidavit by myself from this affidavit.
What is this affidavit? Can you please specify the code?
This affidavit, this one is regarding certification under section 65B of the 65B for normally we're taking the
This is my affidavit under section 65B of the Indian Evidence Act to prove my electronics document. Full stop. Yes.
Grateful. Whose signature is appearing at page 3 bottom?
yeah, this one's myself only. Sir.
Are the contents of this document true and correct?
Yes, this is true.
Chip, let it be kept
Yes.
on record.
That's all.
Lordship.
Plaintiff witness is present. During the examination of the plaintiff witness, documents were marked as exhibit A to A2K. Full stop. Plaintiff has filed the affidavit under section 65B of the Evidence Act. Let the same be kept with the record. Examination in chief of the plaintiff witness number 1 is concluded. Full stop. Counsel for the plaintiff press for time to adduce further evidence. Accordingly, case is adjourned. Let the matter appear on. Give the date. You will bring other witness.
Chip, I shall bring that receiver, Lordship, to prove the receiver's report. Lordship, may I submit one thing? Lordship, may I produce GA number because it is part of the record?
Madam, you give the requisition. I cannot give an idea. You give the requisition of Department for Protection of the GA along with the total record, along with the CS. Give the requisition to the department.
Lordship, in that case, Lordship, I don't think I need to prove the bring the another witness. If
So how you will prove the document?
Lordship.
Date 11 November at 3 p.m.
Grateful, Lordship. Grateful, Lordship. Lordship, do I need to file another affidavit under 65B?
Bring the
Lordship, I shall
detailed affidavit in terms of the section.
Lordship, Great,
Yes,
Lordship.
next.
Deeply obliged, Lordship.
The plaintiff is given liberty to file supplementary affidavit under section 65B of the Evidence Act by disclosing the electronic document in details.
I am deeply obliged, Lordship. Grateful.
Yes, next.
I'm for the petitioner. This is an application. It may Mr. Shamal Sharkar, my lord. This is an application for a judgment upon admission. Affidavits are complete in this matter, Lordship. I can't find the other side here. So
You are for the?
I'm for the plaintiff petitioner.
Who is for the other side?
Somebody had appeared on the last occasion also, Lordship. I can't find. Affidavits are complete in this matter.
Defend number. Who is for the defend number 1?
There is only there
They
are
file the
others are-
affidavit.
the other they file an affidavit. We have filed a reply to reply to that.
Where is the affidavit?
The affidavit is complete, my lord.
एफिडेविट आया क्या?
Maybe it was
Opinion
filed-
opposition है?
it was filed in the
GA5 में?
it was filed- No, opposition reply আছে? Reply আছে, original reply টা?
No reply, no affidavit.
The reply original reply कहाँ है?
No reply, no affidavit.
This is the original affidavit reply with me, my lord. That side is not there.
Learned counsel appearing for the plaintiff is present. None appears on behalf of the defendant. Counsel for the plaintiff has filed affidavit in reply to the affidavit in opposition filed by the defendant. Let the same be kept with the record. But no affidavit in opposition is on record. Let the matter appear on 10th September. Next.
Lord, I appear for the plaintiff in the instant matter, my lord. My lord, GA8 is an application taken out by the defendant number 1 for transfer of the matter from commercial to non-commercial division.
Correct.
My lord, the pleadings are complete, my lord. My lord, in fact, the matter was transferred to the commercial division of the court pursuant to the order dated 1st March 2024, my lord. And on September almost after a year, my lord,
Hmm.
they have taken out this application, which is essentially in the nature of recall, to take it back to the non-commercial side, my lord. In fact, my lord, they are not appearing, my lord. So it's their application, my lord.
So you are appearing for whom?
The plaintiff, my lord.
Who is appearing? Nobody is there. None appears on behalf of the defendant. For the interest of justice, the case is adjourned. Let the matter appear on 24th of September 2025.
Grateful.
Next.
May I please, my lords?
Yes.
I appear for the plaintiff.
My lord, I'm for the defendant, my lord. I'm sorry for not being there physically before your lordship, my lord, but I'll assist your lordship online.
Yes. Lord, may I file my affidavit of service, my lord? As regards, my lord, GA Form 3, my lord, is concerned.
GA3?
GA3, my lord, is my application under order 13A, my lord, of the Code of Civil Procedure.
Okay.
My lord, I have filed, my lord, an application being GA2. My lord, I would humbly pray that your lordship may consider, my lord, disposing of GA2 first before, my lord, passing any order in GA3.
What is the GA2?
My lord, GA2 is, my lord, for extension of time to file my written statement. And GA3, my friend is seeking my eviction. The suit is for eviction. And in GA3, he wants a summary decree. GA3 proceeds on the basis that the defendant has not filed a written statement. But your lordship may consider, my lord, taking my written statement on record. Kindly, my lord, take GA2 for a moment.
The order summary suit.
No, my lord. My lord,
it's not a
suit, my lord, seeking eviction of the defendant, my lord, under section 106 of Transfer of Property Act.
So this application is filed under 38.
13A.
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 Yes.
Of Code of Civil Procedure.
My lord, 13A anyway, my lord, no order can be passed unless I put in a reply. 30 days time has to be given to me, my lord. Those, my lord, things are there in the statute itself. In the meantime, my lord, kindly, my lord, take my written statement, my lord.
And
kindly,
you,
my lord, take.
First, you tell me when you received the GA3.
Yes.
When you received the copy of GA3. Where is the affidavit? You filed
My
the
lord, I have
affidavit?
filed just. My lord, it was served on 28th April, my lord, 2025.
Yes.
30 days, my lord. Lordship, where, my lord?
No, but my lord, my lord, it has come up for the first time, my lord. Your lordship may consider, my lord, first, my lord, allowing my GA2, and then, my lord, perhaps GA3, because it's never been, my lord, listed before. It's come up for the first time before your lordship, my lord.
Running in the list, my lord.
Okay, whatever it is, come or list or not, but you have received, you have to, what is the duty of the defendant? You have to file the written statement within 30 days after receipt of the summons.
My lord, my lord, kindly consider my GA2, my lord, all the timelines are given there. My lord, kindly, your lordship will just take GA2 for a moment.
GA2 is with regard to your written statements.
Yes, my lord.
I am not on the written statement. I am on respect of the affidavit in regard to the GA3. You have received the GA3 in the month of April 2025. Now we are on August, September, coming on September. You have not filed the affidavit with regard to the GA3.
My lord, your lordship, my lord,
law provides 30 days from the date of receipt of the notice. What can be done?
My lord, kindly, my lord, kindly, my lord, consider the section, my lord, for a minute. Kindly, my lord. My phone. Kindly, my lord, consider the section. My lord, subject to correction, my lord, your lordship, my lord, can, there is no, my lord, impediment in your lordship, my lord, granting me time to put in a reply to the GA3, my lord. My lord, kindly consider order 13A.
Yes.
Yes, and my lord, the procedure, if your lordship sees, my lord, rule 4 procedure.
My lord, sub rule 3 of rule 4, my lord.
Correct.
Yes, my lord.
The respondent may within 30 days from the receipt of the notice
Yes.
of the summary judgment.
May file a reply addressing the matters set forth in clauses so and so, so and so. The reply must precisely, my lord, then there are, my lord, directions. But, my lord, nowhere, my lord, does it say, my lord, that unlike, my lord, 120 days for a written statement, that if, my lord, I do not put in my reply, my lord, I'll lose my right forever. Your lordship can always, my lord, be, my lord, liberal, my lord, and grant, my lord, an extension of time. And, my lord, my respectful submission is, my lord, that there is no, my lord, provision which says that I will lose my right, my lord, to put in a reply if, my lord, 30 days have lapsed. These are, my lord, directory, my lord, provisions. My lord, kindly, my lord, if your lordship even considers, my lord, to take my written statement, and if your lordship even treats my written statement, my lord, as a reply, my lord, to this application, my lord, I should be through. Because, my lord, this entire application proceeds on the sole premise that there is no written statement and none of the facts are controverted. Kindly, my lord, now for a moment.
This is the writ of summons.
Yes, my lord, now, my lord, your lordship will take GA2, my lord. Lordship will take GA2. My lord, writ of summons was received on 22nd November 2024.
Correct. Then
Now, my lord, the 120 days expires. Last day was 22nd March 2025.
correct.
My lord, we filed, my lord, the written statement subject to leave being granted by our lordship. Leave was granted, my lord, on 19th of March 2025, and the written statement, my lord, was filed on 20th March 2025, and, my lord, 120 days were continuing till 22nd March. So on the 117th day, your lordship granted leave to us, and on the 118th day, my lord, the written statement was filed. And as on the date of filing of the written statement, my lord, the application for extension of time, namely GA2, was already filed even prior to filing of the written statement. Kindly, my lord, see the date of, my lord, affirmation of the application. The application, my lord, was filed in February 2025.
Yes.
For extension of time. Now, my
Yes.
lord, what is the reason? May I just indicate, my lord? My lord, paragraphs 7 to 11, if your lordship considers, my lord, of my application. My lord, when, my lord, these, my lord, documents, my lord, the suit, my lord, pertains to events which took place in the year 2006, at which point in time, my lord, I was very young, because today, my lord, I'm only 35 years old. So, my lord, back then, my lord, I was in my latter teens. So, my lord, I had to dig out old records. That apart, my lord, my advocate had returned my brief. I had to then, my lord, engage another advocate who, my lord, prepared my written statement. My lord, given all these facts, my lord, the pleadings are there from paragraphs 7 to paragraph 11. And, my lord, I'm within, my lord, the statutory period. Your lordship had allowed, my lord, me to submit it on a provisional basis. Your lordship may kindly, my lord, at least allow my written statement, my lord, to be accepted. My lord, kindly take, my lord, a paragraph from paragraph 7, if I may place, my lord, of my application.
Yes.
It's a simple, my lord. I'm not, my lord, praying for anything exceptional. I'm within the statutory permissible period, my lord. Kindly just, my lord, take my written statement on record.
Look, yes.
That my learned friend's client being honest, my lord, and as simple as what, my lord, possibly I wouldn't have strengthened it. My learned friend just now submitted, my lord, that, and on affidavit he has said that writ of summons was served on 22nd of November. Lordship will kindly have a look at the service report. Ma'am. It is 21st November. That's the first, my lord, misstatement, my lord, if not false statement, my lord, made by the petitioner, my lord.
Yes.
Secondly, my lord, if my lord kindly takes the prayers of this application, lordship will kindly see what are the prayers. It's an application, my lord, if I may use the term, my lord. It's a prelopsis application, my lord, which, my lord, is in anticipation. Lordship will kindly see what are the prayers. An order be passed condoning delay, my lord. What is the date of delay? Not mentioned. In filing the written statement on such terms as to this honorable court may deem fit and proper, and lordship will kindly see the prayer be, my lord. An order be passed granting extension of time to file the written statement beyond the statutory timeline within 30 days and within the outer timeline of one. My lord, this is a case of my learned friend's client, my lord, on affidavit. My lord, when he alleges, my lord, that writ of summons was served on 22nd of November, and he says that outer limit is on 20th of March. And, my lord, I have been able to demonstrate, my lord, that the writ of summons was served on 21st of March. That's one. My lord, in my respectful submission, this application cannot be, my lord, at all considered to be an application, my lord, filed in aid of, my lord, the written statement which was sought to be which has been, my lord, sought to be brought on record. My lord, when this application was pending, my lord, mentioning notice was given to me. My lord will kindly see what was the mentioning notice given in the evening of 18th of March, my lord. Lordship will kindly see, if Lordship kindly turns over and my lord sees that. This is to inform you that we shall mention the above mentioned matter for upgradation, my lord. There is not an iota of word, my lord, by which, my lord, my learned friends, advocate on record suggested, my lord, that they intended to file the written statement. My lord, they only sought upgradation. My lord, what had happened, my lord? This notice was sent to my learned advocate on record by way of email, my lord, in the late evening on 18th, my lord. As a result of which, my lord, we missed, my lord, mentioning time, my lord.
Yes. When you file the written statement?
My lord, written statement, my lord, was filed on the 20th of March 2025. 20th of March 2025.
Yes.
And leave was endorsed by your lordship, my lord, on 19th March. And the 20th day, my lord, was 22nd March.
My learned friend is making one submission which is contrary to the affidavit of him and the prayers. Well, prayer says the outer limit of 120 days. Lordship will kindly see prayer once again. Expires, my lord, on 20th of March.
No, if it is 21st of November is to be taken, so when it will be 120 days will be when is
I think it will be on 20th. It should be, my lord, on 20th of March.
20th.
It should be 20th March. Lord, I am on the conduct, my lord. My lord, that I leave. My lord, that apart. Now, my lord, if lordship can. Thereafter, my lord, I leave it to your lordship, my lord. And then, my lord, I have to, my lord, place my application.
Okay, I am disposing this application.
Here too, my lord, sir.
The defendant has filed an application being GA Com 2 of 2025 in CS Com 785/2024, praying for condoning the delay in filing written statement and for acceptance of the written statement. Counsel for the defendant submits that the writ of summons was served upon the defendant on 22nd of November 2024, and on receipt of the writ of summons, the defendant has contacted the learned advocate and handed over all the documents to the erstwhile advocate for finalization of the written statement. He submitted that the erstwhile advocate could not prepare the written statement, and subsequently, due to his personal difficulties, the erstwhile advocate has written the brief to the defendant. And immediately thereafter, the defendant has contacted the present advocate on record and handed over all the documents along with the plaint and all the documents for filing written statement. By that time, the period of 30 days was over, due to which the defendant could not file the written statement. He submitted on receipt of all the documents, the present advocate on record, present advocate of the defendant has prepared the written statement, and with the leave of this court on 19th of March 2025 has filed the same on 20th March 2025, that is within the outer period of 120 days. He submitted though the defendant has not filed the written statement within 30 days, but has filed the written statement within the outer period of 120 days, and as such he prays for acceptance of the written statement. Per contra, an advocate appearing for the plaintiff raised objection and submits that the statement made by the defendant in the application is not correct. He has handed over the service report issued by the Deputy Sheriff of Calcutta dated 1st of May 2025, wherein it reveals that the writ of summons was served upon the defendant on 21st of November 2024, not on 22nd of November 2024. Learned counsel for the plaintiff also draw the attention of this court to the prayer portion of the present application and submits that the 120th day is expired on 19th of March 2020, but has wrongly mentioned that the 120th day is expiring on 20th March 2025.
He further submit that the defendant has not shown any cause as to why the defendant could not file the written statement within the prescribed period of 30 days and prays for rejection of the instant application. But the learned counsel for the respective parties peruse the materials on record. Though the defendant has stated that the writ of summons was served upon the defendant on 22nd of November 2024, but as per the service report issued by the Deputy Surveyor of Calcutta, the writ of summons was served upon the defendant on 21st of November 2024. Admittedly, the plaintiff has not filed the written statement within the period of 30 days, that is by 20th of December 2024. But the defendant, with the leave of this court, has filed the written statement on 20th March 2025. If the date is taken into consideration, if the date of service of writ of summons, if 21st November 2024 is taken into consideration as date of service of writ of summons upon the defendant, the 120th day would be completed on 20th of March 2025. And this court find that the defendant, with the leave of this court, has filed the written statement on the same day, that is on 20th March 2025, that is 120th day. Considering the above, this court also find that the defendant has shown sufficient cause that initially the defendant has engaged another lawyer, but due to personal difficulties of the erstwhile advocate, he has written the brief, and subsequently the defendant has engaged the present lawyer, and he has prepared the written statement and filed on 20th March 2025. Taking into consideration, this court find that though the defendant has not filed the written statement within the period of 30 days, but has filed the written statement within 120th day, thus one opportunity should be given to the defendant by accepting the written statement, but subject to payment of cost of rupees 5,000 to the High Court Legal Service Authority. Full stop. The defendant is directed to pay the cost of 5,000 in the High Court Legal Service Authority within a week from date. Full stop. The defendant is directed to produce the proof of the payment of the cost to the London Master within a week from date. Full stop. The department is directed to accept the written statement presented by the defendant on 20th March 2025, subject to scrutiny by the department. The defendant is directed to serve the copy of the written statement to the plaintiff within a week from date. Full stop. GA number 767.
One more submission, sorry, my lord. But since, my lord, affidavits have not been called for, my lord, the allegations are deemed not.
Though the plaintiff has not filed the affidavit in connection with GA Comp 2 of 2025, the allegation made in this application deemed to have been denied.
My lord, just subject to correction, one thing, my lord, your lordship has, my lord, indicated in the order that the 120th day would have been 20th March. My lord, as per my calculation, it would be 21st March 2025, because under the General Clauses Act, my lord, the day on which the writ of summons was served would not be, my lord, counted. The counting would begin from the subsequent day. Subject to correction. It's an academic. It's only an academic, because it says.
I will see by correcting the document.
Kindly consider that, my lord.
But now
I'm so grateful.
The plaintiff has filed an application being GA 3 of 2025 under Order 13A of the Code of Civil Procedure, as amended under the Commercial Court Act. It is found that affidavits are completed.
No, my lord, I have
No.
to. My lord, my learned friend does not have right to file. Lordship will kindly give me, my lord, for 5 years thereafter. Lordship.
He wants an ex parte eviction. My learned friend wants an ex parte eviction.
Let the matter appear on.
Kindly, in the meantime, let me.
9th of September 2025.
I'll copy paste my written statement and make it. I'll only copy paste my written statement and make it my. Kindly, my lord, allow me to put in my.
Okay, come on that. I will see to that. No problem. Okay. Come on 9th September.
Very well. Grateful, my lord.
Yes, call the matter.
And for the plaintiff, my lord, today was the date fixed for the defendants to adduce their evidence, my lord.
Well, we mentioned this on the Friday as well. Lordship did not, of course, entertain. Today morning also mentioned, but the witness is not
Though the
not
matter
there.
is fixed, especially fixed today. Though the matter is especially fixed today for witness action, but due to some unavoidable circumstances, the witness of the defendant could not able to appear before this court. Accordingly, the learned counsel for the defendant prays for time. In view of the submission made by the counsel for the defendant, the case is adjourned. Let the matter appear on.
May I make a request, Milord? If Milord they consent, Milord, we can go for commission because it's a disease which is continuing. I can see for last 7 months. Hypertension.
What is suffering from?
He's in Kolkata.
Hypertension.
Hypertension problem is that every now and then the doctor's advice take rest. The witness. So better, Milord, we go there at his residence and do it at our cost. No problem, Milord.
This is a commercial suit as far as the affidavit chief can be given.
Milord, they did the chief orally entirely. They did the chief orally entirely.
That doesn't mean that
in
he
my
can't
time,
do it. He
in
can
my
do it
time,
with
Whether you are ready to
commission, I can do.
Examine the witness on commission.
It will be easier, time
definitely in
consuming.
court because the court gets an idea of what is happening because this is primarily relating to a fraud because there was a movie rights which was.
I am fixing a return. By that time,
Only thing is that on that day, I don't want to embarrass your lordship and myself again with the same kind of prayer.
What is the
age is senior citizen, 68 age 68 Milord. That's the reason I am saying that kindly it will in commission it will be held in 2 days. It will be over here, Milord.
Okay, fully. So counsel for the defendant submit that the defendant witness is 68 years of age and is suffering from various ailments, and as such it is not, and as such he prays for appointment of commissioner for examination of the witness on commission. But problem is that the commission is also not. Then you will say the
at his residence. At his residence.
Maybe, but I am fixing a specific
yes.
time.
Maybe lordship maximum gives 1 month or maximum 2 months.
Witness on commission. Full stop. Counsel for the plaintiff submit that he will bear the cost. He will pay the remuneration of the commissioner if this court appoint the commissioner for examination of the defendant witness on commission. In view of the submission made by the counsel for the defendant, taking into consideration of the condition, age, and the ailment suffering by the defendant. Yes, who can
junior member of the
who can complete the as early as possible.
Mr. Jishan Hawk is there, Milord. He in another matter he is acting as an arbitrator. He is doing good. He can, Milord. He can, Milord, be if my land consents.
Good name. Give the name. Sonsus is appointed as commission, but you have to complete that. No, if adjournment, reject. I am giving power to you.
And only Lakshmi kindly give me liberty to file affidavit of evidence in front of the commissioner.
Sonsus appointed as a commissioner for examination of the witness of the defendant commission in the residence of where is your residence?
But residence is in Salt Lake or Milord or either Salt Lake or any other place. Kindly record it.
You can come to any other place. You can come before this.
No, in case of any venue nearby.
The remuneration of the commissioner is fixed rupees 15,000 per sitting. Full stop. The commissioner is requested to complete the evidence of the defendant witness on commission within a period of 4 weeks from date. 4 weeks from date. And to submit the report before this court. And to submit the report before this court. On 4th of November 2025.
4th of November.
The commission is directed to inform the assistant registrar of this court the date of examination of the witness on commission so as to enable the officers of this court to produce the document before the commissioner at the time of examination of the witness on commission. Release the matter on 4th November for filing a report by the commissioner.
Great, Milord.
Yeah. You continue, Jaiga.
Lordship will realize there are, I think, total Milord 11 days of examination for their witness. 11 days. It took me about
more than 20 minutes a day.
So it takes time. That's what I'm saying. If I go there, it will
call.
I don't know what time.
Please, The last occasion, my lord, I taken your lordship to the share purchase agreement in the MOU with which I am concerned with. And
Before Mr. Thakkar starts, your lordship, one thing. Mr. Banerjee was not aware that it's getting fixed, your lordship. Mr. Banerjee has let Mr. Thakkar complete.
yes, I
will
given him
complete.
notice. I
No,
gave him notice
Notice
that
after the mentioning. That's not the practice.
I had placed before your lordship, my lord, the share purchase agreement and my lord, the memorandum of understanding, and also shown your lordship, my lord, the order of our court in the section 34 application, from which, my lord, it appeared that the respondent number 2 section 34 was dismissed because he did not give a correct agreement, and the respondent number 1 and the outgoing shareholders, their 34 was dismissed because they filed the specific performance late in time. Now it was, my lord, why, I tell your lordship, why this whole thing was fraudulent was, and which is my specific case on oath, that initially the building was, entire consideration was to be paid by the incoming shareholders to the outgoing shareholders, and the incoming shareholders would infuse funds and raise the building. Now what happened, my lord? The incoming shareholders brought in a developer. The developer now took part of the liability of the consideration which the incoming shareholders were to pay, and they paid it to the outgoing shareholders. Therefore, the liability of the incoming shareholders to pay in terms of the original share purchase agreement and my memorandum of understanding came down. That is why your lordship will find I did not make, it is not my case that I have paid in terms of the MOU. The MOU required me to pay 14.86 crores. I have only paid about 11.86 crores. But nobody ever told me that you pay the balance money. Neither respondent number 2 nor respondent number 1 and the outgoing shareholders. Why? Because a developer came in, Siddha, who had to pay part of the consideration. Now this I have stated on oath. Kindly have paragraph 13, my lord, of my application. And I'll show your lordship how they deal with it. This is where the whole fraud happened, because this was suppressed from the tribunal by both parties.
Paragraph 13.
Paragraph 13 of GA1, please, ma'am. Page 15.
Yes.
Sometime after March 2014,
Yes.
the respondent numbers 3, 5, and 7 informed the plaintiff's director that although the original plan was that the new building would be constructed by the respondent number 1,
Yes.
they had now resolved to engage a developer to carry out the construction.
Yes.
The petitioner was informed that the respondent numbers 3, 5, and 7, representing the respondent numbers 2, 4, and 6, had negotiated with one Siddha Estate Development Private Limited for development of the said premises, in terms of which the respondent number 1 would be entitled to 7 floors along with corresponding car parking spaces, and the developer would get the balance 9 floors along with corresponding car parking spaces. It was further represented to the petitioner that with the induction of a developer, the liability of the respondent numbers 2, 4, and 6 under the share purchase agreement would stand reduced, and such reduction would also inure to the benefit of the plaintiff. It was further made clear that on the induction of the developer, the entitlement of the petitioner and the respondent numbers 2, 4, and 6 to the share of profits of the respondent number 1 would now be limited to revenue generated from 7 floors and corresponding car parking spaces. The petitioner agreed with the proposal mooted by the respondent numbers 2, 4, and 6. Now kindly see 14. Subsequently, the petitioner was informed by the respondent numbers 3, 5, and 7 that the respondent number 5 had executed a development agreement as, kindly see, very important, director of the respondent number 1, because one of the incoming shareholders had already become director of R1. On 8th September 2014, the date is also specifically mentioned, my lord, on 8th September 2014 with Siddha Real Estate. Accordingly, the revised consideration payable under the share purchase agreement was now rupees 10 crores odd instead of 20 crores and rupees 37 crores odd as loan instead of 62 crores. Because, my lord, Siddha is coming in. He is getting part of the building now, which he is going to construct. The other amount which he is now paying is the premium on the land value. Okay. The cost of construction is less. You're getting 9 floors. The parties work out that you have to pay so much money extra premium. Now, the petitioner was required by the respondent numbers 3, 5, and 7 to make and duly made payment of rupees 1 crore 84 lakhs on account of consideration for purchase of 18% shares of and in the respondent number 1. This amount was the rounded off figure of 18% of 10 crores. The reduced consideration. Payment of rupees 1 crore was made by the petitioner to the respondent numbers 8 to 19 of the respondent number 1. Particulars whereof are given in a schedule. This is not disputed, my lord, the payment made. Then kindly see 16. From time to time, the respondent numbers 3, 5 and 7 required the petitioner to make further payment on account of its share of payment of loan to respondent number 1. In good faith and trust, the petitioner has made payment of an aggregate amount of rupees 4 crores 73 lakhs 43,000 to the respondent number 1 on account of loan. The respondent number 1 has acknowledged receipt of this amount as loan in its balance sheet for the year ended 31st March 20. This I had shown your lordship, the figures were there. Upon making payment of the aggregate amount of rupees 11 crores 24 lakhs, as stated herein above, it was represented to the petitioner by respondent numbers 3, 5 and 7 on behalf of respondent numbers 2, 4 and 6 that it was not required to make any further payment to respondent number 1 or its outgoing shareholders. Accordingly, the petitioner did not make any further payment, very important, nor was it called upon to do so at any time by the respondent numbers 3, 5 and 7, the respondent number 1 or the outgoing shareholders being respondent numbers so and so. Nobody ever told me, Malad, that your balance amount is outstanding. You have paid only 11 crores, you need to pay 14 crores, please pay the balance. There's not one letter. In fact, on taking such accounts, it now transpires that the petitioner has paid rupees 2 crores odd in excess of its share of payment of loan of rupees 7 crores. I was required to pay only, Malad, 7 crores as loan. I have paid, Malad, more than 7 crores. I paid 9 crores. Then kindly come to 19. The petitioner inquired of R1, 3, 5 and 7 about the issuance of shares of and in the respondent number 1 in its favor and the distribution of profits as construction of the new building was nearing completion. The respondent numbers 1, 3, 5 and 7 assured the petitioner that the shares would be allotted to it in terms of the MOU and it would receive share of profits in the form of dividend proportionate with its shareholding of 18% in the respondent number 1's once sublease of all units had been completed. The petitioner bona fide believed and relied on such assurances. Now, let's kindly see how they deal with it. Kindly have the affidavit in opposition to GA1 affirmed by Mr. Jagdish Sarda, respondent numbers 2 and 3 on 16th of July. Paragraphs, Jagdish Sarda AO 16 জুলাই 2025 GA1 ফাইল করেছো কোর্টে ফাইল করেছো वो बाद में इसमें तो डील नहीं कर रहा ना मुझसे
Yes.
Now, my lord, I have just placed before your lordship, my lord, paragraphs 13 to 19. Now, kindly see paragraph 22 where he deals with these paragraphs at page 16 of his opposition. This is R2 and R3, my lord.
Yes.
With reference to paragraph number 13 to 16 of the application, paragraph 22.
22.
At page 16, my lord.
Yes.
I've shown your lordship, my lord, paragraphs 13 to 19.
Yes.
Two paragraphs I want to place now, my lord, from his opposition, how he deals. With reference to paragraphs 13 to 16 of the application, I deny and dispute each and every allegation, statements also. It is denied that our respondent number 3 informed the plaintiff's director about any change of plan, and no intimation was given by the respondent number 3 to the plaintiff petitioner with regard to induction of a developer by the name of Siddha Real Estate Development Private Limited for development of the said premises. Pausing here for a minute, my lord. All that he is denying is that I did not tell you. There is no denial that Siddha was not appointed. Then kindly read further. The deponent states that the respondent number 2 has been a victim of actions of the respondent number 1 and was compelled to initiate proceedings as against respondent number 1 and other respondents. It is denied that the deponent had informed the petitioner with regard to execution of a development agreement dated 8 September 2014 with Siddha Real Estate Development Private Limited. He's saying only denial is I did not tell you. But there's no denial that this agreement was not entered into. Specific date and agreement.
Admitted with regard to the Siddha real.
Yes, it is admitted. R2 admits. Now I'll show you, Lordship, why R1, my lord. That is why the fraud, my lord. Then kindly see 23. With reference to paragraph 17 to 19, it is denied. Everything is denied, my lord. Then kindly see, there only where denials. The last sentence is the only affirmation. On the other hand, the respondent number 2 was running from pillar to post for the high-handed and arbitrary action of respondent number 1. So, my lord, my case was Siddha came in, my amount became reduced. No, I paid that amount. I have in fact paid excess, and nobody ever called me to pay more money. And your lordship has now seen the denial. Not one letter shown that you have not paid your money, or that we called upon you to make further payments. Now kindly see the opposition of respondent number 1. All of this is suppressed in the arbitration. This whole Siddha angle is totally suppressed by both these parties. Kindly come to paragraph 7 of the affidavit in opposition of Pungshuk Mujumdar, my lord, R1. With regard to the contents of paragraphs 11 to 20, page 29, please, my lord.
Yes.
Your lordship will see paragraphs 11 to 20 are dealt with here. Then I deny and dispute. I deny R5 has informed the plaintiff's director that although the original plan was that the new building will be constructed by R1, they had resolved to engage any construction at all or not. Now kindly see, my lord, who is affirming the affidavit. Kindly see page 5 once, please, my lord. These are telltale signs of fraud. I'll show you, lordship, how R1 is now perpetrating fraud. Kindly see. Affidavit in opposition on behalf of respondent number 1 only.
Yes.
He is denying that R5 did not inform me.
Correct.
He has no business with R5. But only thing is R5 is now director of R1. So R5's denial also R1 is doing now. I deny that R5, that is Mr. Mehta, informed the plaintiff's director that although the original plan was that the new building will be constructed by R1, they had resolved to engage a new developer. I call upon the petitioner to furnish strict proof of the statements made in the paragraph under reference that will come when the suit is tried. Say what will appear from the share purchase agreement. I make no admission as to the correctness. Then, my lord, kindly see. I deny. Everything was only that I did not inform. I kindly see about 8 lines from the top. I deny that the petitioner was informed by respondent number 5 that the respondent number 5 has executed a development agreement as director of respondent number 1 on 8th September 2014 with Siddha Real Estate Development Private Limited as alleged. So this is also admission. Agreement was there. Who has informed is a denial. I deny that there is any revision to the consideration payable under the share purchase agreement. I deny that the petitioner was required by the respondent number 5 to pay any sum on account of consideration for purchase. I call upon the petitioner to furnish strict proof. I repeat and reiterate that respondent number 1 and its shareholders have or had no privity of contract with the petitioner. That's a legal argument I'll deal with. The memorandum of understanding was entered into between R2 and the petitioner has no nexus with R1 or its shareholders. He has received money from me. His balance sheet shows money is received. He says he has no nexus. Then respondent number 1 is not bound by any of the representations or obligations made by R2 to the petitioner under the memorandum. Say what will appear from the, I make no admission as to the correctness. I deny that the respondent number 5 required the petitioner to make any payment on account of payment of shares or loan to the respondent number 1. Then strict proof of correctness. I say that the payments were made by the, now this is where, my lord, I join issue. I say that the payments were made by the petitioner on behalf of the respondent number 2. And the respondent does not have any privity or contract or nexus or link or understanding with the petitioner. Payments were made on behalf of respondent number 2, my lord, then my name would not have been reflected as a creditor in his books of accounts.
So, with the suit filed by the respondent number 1, what would be effect of that?
My lord?
The suit filed by the respondent number 1.
Yes.
What would be the effect?
What would be the effect? That's the point, my lord. Why did he go and file a suit? He says, I have put in the money. Now you take the money which is lying in court. I have no privity. And the suit filed by him, I'm grateful, my lord. The plaint will show that from day 1 he had knowledge. Even before I entered into the MOU, I had paid him money. He has received money from me prior to my entering into the MOU. The MOU records that. Then, my lord, kindly see, I am unaware. Now, kindly see, I am unaware of the excess payments which have been made by the petitioner on behalf of R2 and accordingly refrain from making any comment with respect thereon. None of such alleged excess or additional payments, if any, have been received by R1 or its shareholders. I deny that any assurances were given by respondent number 1 or 5 regarding allotment of shares in favor of petitioner. I call upon the petitioner to furnish strict proof. I deny that any assurances were given regarding receipt of profit. I call upon the petitioner to say strict proof. I state that the alleged entitlement of the petitioner to any of the shares offered in the respondent number 1 was a matter of private agreement between the petitioner and R2, to which the respondent number 1 or its shareholders were not parties. Fulfillment of the MOU was, as appear from the terms thereof, dependent on R2 acquiring shares in R1. This is incorrect. The respondent number 1 was held to be disentitled to the shares of the respondent. Now, kindly see, very important. Respondent number 1 was held to be disentitled to the shares of respondent number 2. I'm sorry, this should be R2 disentitled to R1. As would appear from the award, kindly make a note of this, as would appear from the award dated so-and-so. Consequently, the petitioner cannot claim any alleged entitlement to any shares in R1 on the basis of the MOU dated so-and-so. This is where, my lord, this whole fraud is happening. R1 is saying, you may have paid whatever you've paid. I am not concerned. R2 has lost the arbitration. You cannot claim any shares. My MOU says assignment of right. My MOU says even if I make part payment, I get part shares. Everything is defeated by the award, to which I am not party. R1 knows everything. He files a suit against me after the award, but here he feigns ignorance. I don't know what is happening between you. You have no privity with me. But what is most important, my lord, your lordship would have noted, my statement on oath that when I paid 11 crores, nobody ever called upon me after payment of 11 crores that you need to pay anything more. Not one letter. Neither R1 discloses nor R2 discloses. So, Siddha came into the picture, admitted.
Yes.
Admitted. Siddha, because of Siddha coming into the picture, consideration coming down, no denial. And further, my lord, no denial that no evidence to the contrary at the affidavit states that I have not paid the full money. The defense of R1 is, now that R2 is not going to get any shares under the award, sorry, you will also not get anything. And this is the whole subject matter of the suit now.
Yes.
That whether this decision which you have obtained against R2 can be made binding on me. Because, my lord, Arbitration Act says the award is only binding on the parties. It is not binding on anybody else. It's not a proceeding in rem. And the Arbitration Act also provides that a section 34 can only be filed by a person who's party to the arbitration, nobody else. So I have no remedy.
Okay.
So this is where, my lord, your lordship sees. Then, my lord, kindly have my petition once. Then I have shown your lordship the notice of the mediation proceeding. And how, my lord, I went from pillar to post getting the documents from the parties. Then I have already shown your lordship, my lord, the section 34. Why the 34 of both parties was dismissed. Your lordship has seen that, my lord. Paragraph 23 is a typographical mistake, my lord. It should be order dated 4th September and not 4th August. So paragraph 23, my advocates informed me of this order of 4th September. Then I wrote to respondent numbers 2, 4 and 6 that what is this happening? What is this arbitration between you? I have no notice of this. Then, my lord, kindly see paragraph 25. The respondent number 4 by its letter dated so-and-so replied to the plaintiff's email dated so-and-so, along with which it forwarded a copy of an application being APCOM number so-and-so and a copy of the plaint. Now, this is the plaint filed by R1. The contents of the letter incorrect and denied. Now, what is interesting is, my lord, kindly see. Paragraph 24 of R2. I say I came to learn of this arbitration for the first time from the order of court. Now kindly see paragraph 24, how he deals with this paragraph of mine. R2's opposition, page 17.
Yes.
Kindly see paragraph 24. This I have stated in paragraph 23. Now kindly see paragraph 24, where he deals with it. With reference to paragraph 20 to 26 of the said application, I deny and dispute every allegation except what's mine. It is denied that upon perusal of the order dated 4th August 2024, the petitioner came to learn for the first time of arbitral proceedings initiated by the respondents. In fact, there is no order of 4th August 24. I have clarified it's an order of 4th September, which is also annexed. Now, kindly see. It is stated that the petitioners had advanced knowledge of such proceeding. It is stated that the petitioner has made false statements on oath in such application. This itself should be the ground for dismissal of the said application, not one annexure.
Yes.
Kindly see the bold statements made on oath.
Yes.
And saying the application should be dismissed for falsehood. And kindly see the only documents which are annexed. Kindly see page 24 is annexure A. Then 25 is annexure B. These are all orders made in this suit. And page 27 is the order of the Supreme Court in the SLP from the 37 dismissal. Nothing.
Yes.
He files an affidavit in opposition after 3 months, made such statements or note, does not bother to disclose even one letter he could have shown. How he has told me of this. Then, my lord, kindly come to my petition once. Kindly see paragraph 26 now. From the cause papers of CS number 764 and APCOM so-and-so, the petitioner came to learn that the defendants have falsely alleged that the petitioner has not made full payment of the consideration for 18% shares of and in the respondent. This is the first time, my lord, anybody says that I have not made payment. In the suit which is filed in this court, before that there is nothing given to me. The petitioner states that although the payments made by the petitioner and R2 have been admitted by the defendants, it is falsely alleged that only respondent numbers 4 and 6 have paid the full consideration in terms of the share purchase agreement. This is, my lord, the fraud of respondent number 1. The allegations made by the defendants are false and incorrect and denied. The true and correct facts are stated in the written statement filed by the petitioner in relation to CS.Com 764. So respondent number 1 now, my lord, says in the suit that you did not make full payment. Sorry, you cannot get anything. Before filing the suit, there is not one letter from any of the parties saying I have not made full payment. And I have, my lord, filed my written statement there. Then, my lord, kindly see the defendants, I am entitled to 18% shares. Then kindly see the particulars of fraud at page 21. The defendants and each of them have perpetrated fraud on the petitioner, particulars whereof as follows. The defendants fraudulently conducted arbitral proceedings between themselves in spite of knowing full well that the petitioner was entitled to 18% of the shares of respondent number 1. The defendants fraudulently conducted arbitral proceedings knowing fully well that the petitioner made full payment of the agreed consideration of rupees 8 crores 84 lakhs 90 for transfer of 18% shares of the respondent number 1. And then kindly see E. The defendants conducted arbitral proceedings between themselves, suppressing that 18% of the shares of and in the respondent number 1 stood assigned to the plaintiff. The agreement records that. MOU records the shares are assigned. The defendants fraudulently conducted arbitral proceedings between themselves without disclosing and suppressing that the petitioner had made full payment of the agreed consideration for transfer of 18% shares in favor of the plaintiff. So this is the case which I come to court with. Now, the immediate, and what is the relief? Now, your lordship kindly sees, because of this fraud, what do I claim? Paragraph 36, please, my lord. I am not claiming specific performance because there's an award. Now, a lot of water has flown under the bridge. They've dealt with the property. So all that I claim is now, my lord, damages. Can you see paragraph 34 once, please? I'm so sorry, my lord.
Yes.
32 is, my lord, my refund of the monies which I have paid.
Correct.
There is no dispute. I have paid this money. I just want to show your lordship, my lord, once in the opposition what they say, my lord, so that this becomes clear that there is only a bare denial. Kindly see, my lord, paragraph 27 of R2's affidavit, page 19.
Yes.
Paragraph 32 is dealt with in paragraph 27. There is no denial that I have paid 11 crores 24 lakhs 78,832.94. No denial.
Yes.
Now, my lord, kindly also see the affidavit in opposition of R1, page paragraph 32. He deals with in paragraph 9.
Paragraph page.
Page 34, please, my lord. Of affidavit in opposition of, I could have got a judgment on admission on this for want of denial. And you see paragraph 9. With regard to the contents of paragraphs 31 to 39. So he deals with 32 here. Your Lordship will see there is no denial that I've not paid 11 crores 24 lakhs 78,000. The only denial is I am not liable to pay. I deny about 8 lines from the top. I deny that the award is not binding or that it does not affect its rights in respect of 18 or at all. I deny that the petitioner is entitled to claim any amount from R1 or its shareholders as alleged or at all. The only denial is you cannot claim from me. But the fact that I have paid, there is no denial. And cannot be denied because this is, my lord, the payment made through banking channel. I'm not on the cash component.
Yes.
This is a payment made through banking channel. Every payment is recorded. So it can't be denied. So what is my suit for? So I say give back my 11 crores 24 lakhs along with interest. Then, my lord, kindly see 33. Petitioner has suffered loss and damage by reason of the defendant's failure and or refusal to transfer 18% shares of and in R1 to the petitioner. The petitioner Petitioner states that the purpose of acquiring the shares of R1 was to exploit the leasehold right of the respondent number 1 in the said premises by constructing a new building thereat, which would be used for commercial purpose. This is also, my lord, recorded in the MOU. As a shareholder of R1, the petitioner would have earned profits from sublease of the new building in the form of dividend proportionate to its 18% stake in R1. So 90,000 is the square feet which is in R1 share. I claim so much damages. I cannot get security for damages, but I'm just showing your lordship what is the structure of the suit. So I am entitled to claim, my lord, paragraph 36, refund of monies, which is now 27 crores odd, and damages of 25 crores and further interest. Now kindly see 38. The respondent number 1 claims that it has already deposited rupees 26 crores odd in court pursuant to orders passed by this honorable court and thereby discharged its liability to repay the plaintiff. The petitioner is entitled to refund of the consideration paid by it from the monies deposited in this honorable court and to appropriate the same in pro tanto satisfaction of its claim as stated in paragraph 32. Respondent number 2 is taking steps to withdraw this amount and has instituted EC number so-and-so. Petitioner is entitled to and claims perpetual injunction restraining the defendants from withdrawing any amount deposited with the registrar original side without making payment of the plaintiff's claims as stated in paragraph 32 and 34 above. Then kindly see the reliefs in the suit. Declaration that the award dated 29 June 2023 made in the arbitral reference between the defendants is not binding on and does not affect the right, title and interest of the plaintiff in respect of 18% shares of and in the defendant number 1. Decree for 26 crores, my lord, that is the refund money. C is decree for 25 crores 5 lakh, that is the damages in lieu of allotment of shares and inquiry into damages. Now, my lord, then also kindly see prayers E. Perpetual injunction restraining the defendants from withdrawing any amount deposited with the registrar original side of this honorable court pursuant to orders made in AP number so-and-so without making payment of the plaintiff's claims as stated so-and-so. The amount deposited with the registrar be pursuant to orders made be made over to the plaintiff in pro tanto satisfaction of its claim. So now, my lord, I don't want to preempt what they will argue in GA2, which is their section 8. But the reliefs which I have claimed here, primarily A and C, are beyond the scope of the MOU because they are directed against the other respondents who are not parties to the MOU. The arbitration agreement in the MOU does not cannot deal with prayer A, cannot deal with prayer C. And the fraud which is alleged against all the respondents cannot be covered by the arbitration agreement in the MOU. The other respondents are not bound by that MOU. They say or the arbitration agreement therein. Whether they are bound or not is a different matter, but the arbitration agreement, they are not party.
Yes.
And one arbitrator, my lord, cannot set aside another award. It's like, I don't know why I will argue when they argue their aid, that is only dilatory. So now, my lord, after I file the suit, parties are requested to go for mediation. That is the view of the coordinate bench, that perhaps it can be settled because 11 crores, there is no dispute. Now, after affidavits also, there cannot be any dispute. During the pendency of the mediation, the entire money is withdrawn from court by respondent number 2. Only about 8 crores is left, which is not sufficient to cover my claim as on the date of the suit of 25 crores. So therefore, my lord, in this application, I pray for directions. Now kindly see the reliefs which I have sought in this application. I was, my lord, aware that I might be late in moving this application. So therefore, I made the prayers, even contemplating that my application, they might hear it, might not be moved, my lord. Kindly see paragraph 44, 43 onwards, 42 onwards, my lord, why I want this security to be brought back to court. The petitioner is entitled to refund 42, my lord, at page 30 of my application.
Yes, yes.
Petitioner is entitled to refund of this amount of 11.24 crores. Respondent number 2 is wrongfully trying to take away the entire amount of 19 crores. If the respondent number 2 is permitted to take away the entire amount of 19 crores from this honorable court without securing the petitioner's admitted entitlement of 11 crores odd, the petitioner will not be able to recover these monies from respondent number 2.
So now this amount has been taken.
Yes.
Leaving aside the 8 crore.
Only 8 crores. My claim alone.
That has been in terms of the order of the Supreme
Yes,
Court.
because I was not, that was all flowing from the arbitration. I was not party there.
Correct.
So now, my lord, kindly see paragraph 43. Respondent number 2 is in involved circumstances and has huge debts and liabilities. This will evident from the audited balance sheet. I'll show your lordship the audited balance sheet. Respondent number 2 has not responded to the petitioner's notice dated 11 September 24 and is avoiding the petitioner. The respondent number 2 has made its intentions clear that it will not return the sum of rupees 11 crores odd to the petitioner. This is my money. He has taken away. If the respondent number 2 succeeds in receiving the entire amount of 19 crores, which includes the sum of rupees 11 crores receivable by the petitioner, the respondent number 2 will siphon off the entire amount from its bank account and secrete the same so as to render the decree which is likely to be passed in favor of the petitioner infructuous. Then is the claim on damages, my lord, paragraph 46. Then kindly come to order 38, rule 5, pleadings I have shown your lordship. 47, 48 is order 38, rule 5. 49, my lord, is order 39, rule 1B. Petitioner is entitled to and seeks an order of injunction restraining R1 and R2 from withdrawing these monies without keeping aside 26 odd crores. Now kindly see 50. In the event the respondent numbers 1 and 2 have already withdrawn the sums deposited in this honorable court, injunction be made restraining the respondents from operating their bank accounts without keeping aside a sum of rupees 51 crores odd, and then the reliefs which are sought. I was, my lord, I was able to move the application before they withdrew the money, but the honorable court was of the view that parties should go to mediation and try to resolve. The mediation, I was very confident mediation would not work. It did not work.
Yes.
Now, my lord, at that time, my lord, I had said that he should keep the monies aside in his bank account because there is now on the pleadings after affidavits, no dispute about monies paid. The MOU clearly says, clause 9, when you get the money, you will immediately refund to me. So, my lord, this is a fit case where your lordships will, I've gone a step further in the supplementary affidavit which I have filed. I have sought a mandatory injunction directing him to bring back the money to court. Because
money to court
which he has withdrawn from court after the suit.
That is the Supreme Court order.
Yes, that may be that is in my suit now. The Supreme Court was not concerned with this case. I was not before the Supreme Court. Supreme Court only said, because the two of you have admitted that he's entitled to this money, you take it. Supreme Court did not know the full picture. So I'm not telling your lordship to override. That is, I cannot make that prayer. So the now, my lord, why I say mandatory injunction directing him to bring back the money is twofold. His conduct during the pendency of the application, during the pendency of mediation, withdrawing the entire money. A. Second, his conduct in the affidavits, there is no defense.
Yes.
And when a mandatory injunction is granted, my lord, it is granted to restore status quo ante as on the date of the suit. That is a settled law. In exceptional cases, your lordships direct restoration of status quo ante on the date of the suit. On the date when the suit is filed and the application is moved, the money was in court. That is all that I seek. The money should be brought back to court. Keeping the money in his bank account, I tell your lordship, will not serve the purpose, because your lordship is now aware these IBC proceedings. Once an IBC proceeding start, any money in his bank account I cannot touch. It goes. There's no relief. That is why our division bench has held that if any IBC proceeding is going to be held against you, you inform the plaintiff immediately if you receive notice. But that will not serve the purpose here, my lord. Saving notice, all this will not serve the purpose. This is my money. He has withdrawn. I am entitled, my lord, to return of these monies. May I just cite the few cases on this, my lord? That prayer which I have made, my lord, is in AP. I'm sorry, my lord. I'll continue tomorrow if your lordship permits. Let it retain its position in the list. I don't think I will get a time. If there is a time, my lord, I'll be obliged, but
At the learned counsel for the plaintiff has argued the matter at length, but due to paucity of time.
oh, tomorrow your lordship is not. Tomorrow this court will not be. I'm sorry.
The same
Tomorrow and day after.
I forgot.
Your lordship is not.
And due to paucity of time, it will not be completed.
On Tuesday, Wednesday.
Let the matter appear on
Thursday, if it commences, then my lord, I will just finish GA1. They can start. Reply to GA1.
28. 28 under the same heading.
20. Great. Athas. Lord, is there any free time in your lordship's board? If I
And then there is no free time. If
Let
you
it
get
retain
the
its
chance, then you
new motion, my lord. Grateful. Grateful.
Post affidavits.
Yes, call them.
Retain here. Deeply.
Boss title Achiki.
Lordship, I appear on behalf of the defendant in this matter. Today, GA3 is listed. That is my application under Order 14, Rule 2. I am being led by Mr. Choyan Gupta.
Choyan Gupta. Where is Choyan Gupta?
Though we had concluded our opening submissions, but since it is being taken up after considerable gap, could I just briefly highlight the points on which we were moving this application? And thereafter, my lord, my learned senior friend can. My lord, will kindly see the plaint once.
A brief is tied in an inseparable knot.
But very short issue involved in this, very small. My lord, the plaint case proceeds on the basis that my lord, the plaint case proceeds on the basis that, my lord, the defendant has become a trespasser. So it's a suit for eviction of a trespasser. Now, my lord, if your lordship kindly takes a look at paragraph 5 at page 3 of the plaint. In fact, I'm sorry, I should show from paragraph 3 at page 2. The original tenant was Gangadhar Bagadia. Your lordship would find that at paragraph 3.
Yes.
And
So
my lord,
I have already taken note of it.
yes, just to in a bullet point, my lord, just to indicate, my lord, what our case is, why we have taken out this order 14 rule 2 application is, my lord, the plaint case proceeds on the basis that the original tenant was somebody after who had passed away, my lord, prior to coming into effect of the 97 Act. This is where the main meat of the matter is. So if the original tenant passes away before the coming into effect of the 97 Act, then the tenancy is governed by the 1956 Act. If a tenancy is governed by the 1956 Act, then this defendant has become a tenant under the 56 Act under 2H. So now they have filed a suit under the new Premises Tenancy Act of 1997 against this defendant. They were proceeding with the matter. Suddenly, one fine morning, they think that they will not proceed with the matter. So they withdraw the suit.
Return and file this.
No leave taken. They withdraw the suit. Then they sue a same defendant in the capacity of a trespasser. So, my lord, I would humbly submit that when a tenancy is already there under 2G for the tenant upon the death of his father, because 2H, my lord, did not specify any time period, 5 years, nothing was there. With the passage of the, my lord, with the death of the original tenant, the son automatically becomes a tenant. That is the departure in the 97 Act. So, my lord, they treat that. They file a suit. Otherwise, had they not treated me as a tenant, they wouldn't have filed the suit under the 1997 Act. So, my lord, and in any which way, by their pleading in paragraph 8, where they have said 7 and 8 that 1982 the original tenant passed away. So, my lord, I am already a tenant. Without taking recourse to, my lord, the West Bengal Premises Tenancy Act, without a notice under Section 6, no eviction suit can be made to me. That is my short point.
Yes, Mr.
No, wait, just to recap, it's been taken up after. And my lord has said that it has noted all the points. Just giving. But could I take your lordship's leave? There's a 4 p.m. fixed matter.
Well, kindly first take the prayers in their application. Where is the prayer in the application? IAGA 3. Order 14, Rule 2. On the basis of preliminary issue.
Yes.
So question of law, preliminary issue or not. So since they have restricted to 14, my task has become easier. Well, your lordship has already been told the facts, but what the most relevant fact which has not been brought to your lordship notice, and on the basis of which the present suit has been filed, which is my cause of action, well, is the simple fact. Well, my suit is entirely based on the definition of Section 2G. Definition of a tenant as my lord provided under Section 2G of the West Bengal Premises Tenancy Act 97.
Yes.
My lord, my suit may succeed.
Yes.
I may finally fail. So, my lord, what the case that I have made out is X was a tenant, admittedly a tenant under the West Bengal Premises Tenancy Act 1956. X dies, leaving behind Y, which is my defendant. I accept Y as a tenant. No dispute. I file a suit. I file an ejectment suit.
Under the old act.
No, under the new act.
Earlier.
Under the West Bengal Premises Tenancy Act 1997. But I filed this in the year 2000. But then comes the amendment to the 1997 Act. So my suit continues. But then I realize that, my lord, I am continuing a suit against a person who by operation of law
Not a tenant.
has ceased to be a tenant. He was a tenant.
Correct. Ceased to be a tenant.
Yes, by operation of law under the 97 Act, which is not my making, it is the legislative intent to restrict tenancy rights to the legal heirs of original tenants.
When the original tenant died?
Well, our original tenant died
prior to the amendment.
Prior, much prior. So I don't say that give me a decree right now. I don't say that.
Decide in the trial.
So it will be decided in a suit. So what I have done is, he died in 82. So the act, the Section 2G, as your lordship is well aware, If you if I may just trouble your lordship once with
Give the
the
97.
section once.
Original tenant died 82.
My lord. So when I filed the suit, the new act had not come into force.
Correct.
So the new act came into force on and from 10th of July 2001.
Correct.
So I filed the suit accepting him as a tenant under the 56 Act.
Because that time this law was not
Correct.
there.
So if your lordship will kindly see once my pleading in respect of that. My lord, kindly take paragraph 5 once, my lord, of the plaint, which is a part of GA1. My lord, GA3, I think they've not annexed. Has the plaint there in GA3?
Yes.
Yes, it is there.
Oh, it is there. It is there. No.
No. Old suit is there.
Old suit is there. This is the old suit.
Old suit.
No. I am talking about the present plaint, my lord.
Yeah.
My lordship kindly takes the trouble of taking GA1 once. In GA1, my lord, we have annexed a copy of the plaint, which starts at page 14. And if my lord will kindly come to para 5 at page 16.
J1 का है, J1 का application का है.
GA1. Page 16. It starts at 14. Kindly come to 16, para 5.
Yes.
After issuance of notice under section 13(6) of the West Bengal Premises Tenancy Act against the defendant, the plaintiff filed a suit for eviction under the Act of 1956.
Where from your reading?
Para 5, page 16. Para 5, which is the continuation of the plaint in GA5.
Yes.
My lord, at paragraph 3, if I am showing your lordship, my lord, kindly turn back to page 15 once, which is where the plaint starts.
Admittedly, he was.
Yes. No doubt about that.
Yes.
So, my lord, originally Gadadhar Bagadia was the plaintiff. Then my lord, kindly take 5. 13(6) notice issued under the 56 Act. Then the plaintiff filed this eviction suit under the 1956 Act before City Civil Court, which was registered as 346 of 1995. Then suit was subsequently transferred to the Small Causes Code, renumbered at 890 of 2000. Third defendant in the suit, written statement where we came to learn for the first time that he has died. From the written statement, we came to learn that the original tenant died in the year 1982.
So you filed the suit against whom?
B. Bagadia and Company.
91 and 95.
Yes.
95 you filed the suit against the Bagaria.
Yeah, G. Bagadia and Company. That
And
is there,
Calcutta.
my lord, in GA3. They have annexed it. Your lordship will find. If I may just trouble your lordship once to, apropos this, my lord, kindly take the GA3 and turn to page 21. Your lordship will find the plaint.
Yes.
Well, the cause title will be there. This is the written statement filed.
G. Bagaria and
Plaint is at page 11.
Yes, G. Bagaria. Yes.
Correct. Then, my lord, what they say is that
So in the written statement, the
they disclose this fact. So if your lordship comes back to the plaint, I say I discover this from the written statement, and thereafter, then I say para 8, the original tenant having died prior to coming into force of the West Bengal Premises Tenancy Act 1997, and the present defendant being in occupation of the suit premises as a legal representative of the deceased tenant, the defendant is not a tenant within the meaning of 2G of the Premises Tenancy Act. In view of the subsequent developments and the fact that the defendant is a trespasser and continues to remain in occupation as a trespasser of the suit premises after the promulgation of the Act of 1996, the present suit filed by the plaintiff has become infructuous. The previous suit, I stand corrected. And the plaintiff has taken steps to withdraw the same. The suit premises was let out for non-residential purposes. It is an undisputed fact that defendant is a legal representative of the original deceased tenant and continues to be in wrongful possession. From the written statement, I say that then my lord kindly take para 11, which is the sheet anchor of my present suit. The plaintiff states that the defendant has no defense to the plaintiff's claim for recovery of possession. Admittedly, the defendant, in view of Section 2G of the 97 Act, does not qualify to be a tenant, as in is in illegal and wrongful possession of the suit property on and from 10 July. Moreover, the defendant has also unequivocally admitted and acknowledged that the defendant is occupying suit property as a legal representative who has died prior. So the plaintiff says the defendant no right. So he is in illegal possession from July 2006. So I say that he continues to be in possession. So it's a continuing cause of action. He's a trespasser till today.
So how you are coming on the illegal possession of 2006?
My lord, because 5 years.
Died
10th July 2082, but he has a right under the act, if your lordship will see the definition, for to remain in occupation for 5 years. So that is there in 2G. If my lord will kindly
82, 5, 87.
No, 5 years from the date of coming into force of that. From 82, at 82, 56 Act was in operation. So by virtue of the provisions of the Act, tenancy was hereditary.
Yes.
And there was no prohibition or any restriction on the tenancy right of legal heirs. So, my lord, like the Delhi Rent Control Act, these amendments were brought in. So restrictions imposed, old act repealed. And then comes the new act. And your lordship is also aware of the fact that under the new act, the suit under the old act is saved.
Correct.
So I cannot take recourse to the new act if I pursue that suit.
You will be out.
But by operation of law, it is, of course, our understanding of the law. The court will decide if I am right or wrong. So our limited understanding is
2005 years.
2001 to 5 years, 2006. This is our understanding. This is the plaint case made out. So the court at this stage has to proceed with the case made out in the plaint.
Yes.
So what are we saying? That here is a defendant, a tenant.
Yes.
Who was admittedly a tenant under the 56 Act.
Okay.
I accept him as a tenant under the 56 Act. I issue him a statutory notice under section 13(6).
Yes.
I initiate a proceeding for eviction under the 56 Act.
Correct.
That proceeding continues. When the suit is pending, the 97 Act is promulgated. The 56 Act stands repealed. But under the repeal and saving clause of the Act, if my lord kindly takes the Act once. Give the 97 Act. (42).
ये तो टीका टेनेंसी
premises tenancy.
ये आपके पास है वही
आपके पास है.
दीजिए दे
Repeal and saving clause निकालो, don't. 45.
Yes.
45. Section 45.
Yes.
First subsection, Act is repealed, 56 Act repealed.
Yes.
Then my lord kindly take. Notwithstanding such repeal, all suits and other proceedings under the said Act, which would be the 56 Act, pending at the commencement of this Act, before any court or any other authority shall be continued and disposed of in accordance with the provisions of the said Act, as if the said Act had continued in force and this Act had not been passed. So it's a complete saving clause which saves the proceedings under the old Act. So my old suit will continue under the 56 Act.
Correct.
So now what I did is, I withdrew the suit. I will suffer the consequences. I have withdrawn the suit. I say, after the new act has come into force, the act gives rise to a fresh cause of action to me. By operation of law, the law has changed. There is a change in law. Now, what is the change in law? My lord will kindly take 2G once.
So you could have been continue with this suit.
I could have. Then I had to get a decree under the 56 Act.
56 Act.
I could have got the decree.
Correct.
But I have chosen not to continue with that suit.
What was the cause of action for filing the suit before?
Subletting and default.
Subletting and
Default. So I had to prove subletting and default to get a decree under the 56 Act.
Correct.
Now what I have done is, after the new act has come into force, I say that by operation of law and after the
you need not to prove these two contents.
no, so if he does not qualify to be a tenant under the old act, that will eventually be decided in the suit. I can understand that. That hurdle I have to cross. Now the question is, if your lordship will see the definition, the question would be this definition. If the definition restricts the right of a tenant, tenant means any person by whom or on whose account or behalf of the rent and premises is, but for the special contract would be payable, includes any person continuing in possession after termination of tenancy and in the event of death. Well, this is where we are. In the event of death of any tenant, also includes, comma, for a period not exceeding 5 years. From the date of death of such tenant, or from the date of coming, I am in or from the date of coming into force of this act, whichever is latter.
So your letter is that 5 years of the 2000
from 2001. His spouse, son, daughter, parent and widow of his predeceased son, who were ordinarily living with the tenant up to the date of death of the tenant as a members of his family, and were dependent on him, and who do not occupy any residential premises, and in respect of premises let out for non-residential purpose, this was included by way of an amendment, and in respect of premises let out for non-residential purpose, his spouse, son, daughter and parent who were ordinarily living with the tenant up to the date of his death as members of his family and were dependent on him or a person authorized by the tenant who was in possession of the premises, but shall not include any person against whom a decree or order has been passed. So, well, if your lordship can make a note, this non-residential part was brought in by way of an amendment in the year 2002.
Yes.
So, well, here is a classic situation, unique in its own, that 56 Act suit pending. Then what, by operation of law, we say, by operation of law, what we say is that you have ceased to be a tenant in view of the promulgation of the new act. Now, their point is, you have continued with the suit for so many years. The fact that I withdrew the suit and filed a new suit,
you have taken the risk.
I have taken the risk. I will suffer the consequence. But you cannot say that that non-suits me.
So this will be an issue.
Of course it will. Now this issue, in my respectful submission, cannot be a preliminary issue. It has to be an issue in the suit. I don't doubt that. But this would be a mixed question of law and fact.
If at all also, if it is a preliminary issue, if the preliminary issue decided, the suit will decide it. If the preliminary issue...
Then I will not get my decree. Again, the main decree, I have to get my suit has to go for trial. Your lordship can understand this is a...
Prayer A.
Yes, my lord.
Try the present suit on the basis of the preliminary issue as urged in paragraph 28. So if the preliminary issue, if the court finds, yes, you are under the 2G.
Or I am entitled to what will? Preliminary issue, if your lordship will see, 14.2 is jurisdictional issue.
Correct.
There cannot be any jurisdictional issue here.
Only whether their suit lies or...
Correct. Whether I get the decree or not. Court may come to the conclusion that no, he is a protected tenant. So then my suit will fail. But that can only happen at the final trial of the suit. Where is the question of lack of substance jurisdiction?
But I think there is one judgment.
My lord.
Have you gone through?
Which one, my lord?
Supreme Court has, my judgment was there, that was affirmed by under this 2G,
Yes.
affirmed by the division bench.
Yes.
Okay, but the Supreme Court said that no, it can continue. I could not remember that.
That would be extremely relevant.
I will today I will check. And somebody, Mr. Who was
If your lordship can give the anybody who had appeared in the matter, we can inquire from that particular advocate. And
Mr. Mukhopadhyay is having that.
Mr. Mukhopadhyay.
Mukhopadhyay is having, and Mr. I think Sabyasachi Chaudhary had appeared in the matter.
Okay.
He got the decree.
Okay. Okay.
It was affirmed by the division bench, but
Yes.
the Supreme Court has set out.
And said that trial should happen.
No, it
Then?
tenant can continue. The legal heirs can continue. Upset
Is
the
your
court.
lordship referring to Rajesh Mitter?
I don't know,
But that is not from your lordship's judgment.
It's my judgment. I think it is which matter. I will see. See to that.
Your lordship gave the decree to the landlord.
Yes, landlord for eviction.
No, I was there. Because
And Justice Tandon has affirmed my judgment. And it was,
that I was for the tenant.
yes, no, but before me you are not appeared, I think. So.
No, I was in the appeal.
I
was in the appeal. Possibly your lordship is referring to Rajesh Mitra.
Might be.
Yes. Is your lordship referring to this judgment?
Let me see.
Of the Justice Sudhanshu Dhulia?
Yes.
Yeah.
Yes, this is a judge.
This is the one. Then I have to deal with this, my lord. I'll tell your lordship, my lord. My lord, if your lordship, even assuming for the sake of argument, my lord, I can only tell your lordship this.
I don't know whether they filed a review.
Yes, review has been filed. I am told, this is my personal knowledge because I know the review applicant. They are getting the review. They have mentioned it. Possibly the review is going to get listed anytime. Because I'll tell your lordship, my lord, this judgment is contrary to.
That's what I'm telling. It's a
6th division bench judgment of this court, 3 subsisting Supreme Court judgment of 3 judges bench, strength of 3 judges, larger strength.
Yes, judges.
Because effectively this judgment says that legislature cannot restrict the right which has by operation has given by a previous enactment, which is effectively under the Delhi Rent Control Act. In DC Bhatia's case, Supreme Court 3 judges bench has exactly said the opposite.
Correct.
Where, my lord, if your lordship recollects, there was an amendment to the Delhi Rent Control Act where the protected tenancy, the statutory protection to the tenancy was restricted to a quantum of rent. Only tenancies below 3,500 will get protected. All tenancies above 3,500 has no protection under the Rent Act. So what happened is 90% of Delhi lost the protection. As your lordship is aware. So that took away protected tenants by virtue of the amendment, the protection given to a class of tenants. By virtue of the amendment, they lost the right. They said that cannot be. This was the challenge. Multiple writ petitions were filed. Eventually, that matter went to the Supreme Court and the Bhatia judgment happened. Give the Bhatia judgment.
Here, the statute, in case of legislature intent to make a law retrospective, then such intention of the legislature must be shown clearly and unambiguously. And
if my lord takes this judgment, your lordship will looking at Rajesh Mitra, right? My lord, kindly take Rajesh Mitra. Unfortunate, but this is where we are. My lord, your lordship will find Well, there were a few judgments of our court which effectively was affirmed by the Supreme Court. The division bench of Justice Sanjeev Banerjee in Nasima Naki, exactly this was held.
But
But
the Supreme Court has taken the another judgment.
Single judge in Gautam De, Justice
Yes,
Dipankar
yes,
Datta's view has affirmed. And my lord, interestingly, the Dipankar Datta's view in Gautam De, sitting singly in civil division, was overruled by not one, 3 division benches. First in Sushil Kumar Jain, then there is another one, and the third one was in Nasima Naki. And Nasima Naki got approved by the Supreme Court.
Correct.
That this is the legislative intent. Court cannot interfere.
But what can be done?
No, now I'll tell your lordship what can be done. I have a judgment. My lord, my argument now will be before your lordship that if before a high court, if it can be shown that there is a Supreme Court judgment laying down the proposition, and there is another Supreme Court judgment of a larger strength which has a contrary view and not considered by the 2 judges subsequently,
That will
be
taken into consideration.
Now, my lord, kindly allow me to place that first. Then it will be easier for your lordship, my lord. This is, give him the Calcutta victory. This is the old division bench judgment of the Calcutta High Court, our High Court, my lord. Ashok Kumar Rai versus Ashok Arora. I'll tell your lordship what was the facts. Here what had happened is, it was an appeal from an order passed in a contempt jurisdiction. So a point was taken by the contemners that the appeal under section 19 of the Contempt of Court Act is not maintainable. Why? Because 19 says that only if an order of conviction or an order holding the contemners in contempt is passed, only then appeal, not otherwise. So they relied upon a 2-judge bench judgment of the Supreme Court. There are 2-3 judgments your lordship will see here, referring what is the judgment in the case of Purushottam, and there are the other 2 judgments. Now, my lord, kindly first take the issue which was there, that your lordship will find. My lord, from paragraph 7. SG does, my lord, this is a SCC copy, it may not tell you.
1991.
My lord?
1991 SCC?
No, my lord. No, my lord.
Ashok Kumar Rai.
Ashok Kumar Rai, which is 96 Calcutta Weekly Notes, page 278. My lord, kindly take that. You take, open the para. Yes, it is the same.
Page,
it is the same.
Paragraph?
Para 7.
Yes.
Let us now examine whether the impugned order is appealable under section 19 of the Act. So, my lord, this was the issue. No, my lord, kindly take the para 9 at the bottom. Bottom will not match, no? It has been argued on behalf of the respondent that section 19, a right of appeal, is confined only to order a decision of the High Court in exercise of its jurisdiction to punish for contempt. Then, my lord, kindly take my lord, para 10 deals with whether it is a appeal or not. My lord, kindly now take paragraph 12. We thus find that there are sufficient and persuasive indications in the provisions of the Act itself in coming to the conclusion that the ends of justice may be defeated in a good number of cases if the words and expression used in section 19 are not given their natural meaning, and if words like or order occurring in the expression execution or punishment of order appealed against are treated as redundant and surplusage, contrary to the established principles of interpretation, that no word or expression used by the legislature should be taken as redundant or surplusage. To give a restricted meaning to the provision of section 19 as desired by the respondents will be tantamount to deleting certain words and expression used by the legislature in section 19, which we are afraid cannot be done. Now, my lord, your lordship will see. Now, my lord, kindly take the judgments which has been referred and the contradiction. My lord, your lordship will find at paragraph 15 there is a reference to a judgment of Baradakanta versus Chief Justice.
Yes.
And that, my lord, which is 1976 Supreme Court 1206. As your lordship found that, my lord. Reference is there in paragraph 16 also.
That is year 1974 SC.
76 Supreme Court 1206. Yes, yes, your lordship is correct. Your lordship is correct.
1974.
Right, right. Then there is another judgment referred in para 16, which is Baradakanta versus the Odisha High Court, which is 76 Supreme Court 1206. Then your lordship will find this is where it starts. Lord, kindly take 16 once.
Yes.
It has been observed that only those orders or decisions in which some point is decided or finding is given to the exercise of jurisdiction of the High Court to punish for contempt are appealable under 19. Then it goes on. So then just a few lines after that, there is a sentence starting with, so this decision of the Supreme Court, like the earlier decision in 1974 Supreme Court 22355, which is the other one, other Baradakanta,
Yes.
does not say that except punishment, no other order decision is appealable under section 19. On the other hand, it formulates the proposition that only those orders or decision in which some point is decided or finding is given in the exercise of jurisdiction by the High Court to punish for contempt are appealable. The distinction between the two Baradakanta cases, that is 74 and 76, the appeal was preferred against an order refusing to initiate contempt. Then, my lord, then a few lines below that, then your lordship, in the former case, the appeal was held not maintainable on the ground that the exercise of jurisdiction to punish for contempt commences with the initiation of the contempt proceeding and not earlier, and in the later case, an order which was posed after the initiation of the contempt proceeding, but in which point such and such. Then, my lord, kindly see then Purushottam, para 17.
Yes.
78th Supreme Court. It has been held that mere initiation of a proceeding for contempt by issuance of a notice under section 17 on prima facie view that the case is a fit one for drawing up the proceeding does not decide any question, and hence an order merely initiating the proceeding without any further does not decide anything against the alleged contempt cannot be appealed against us such and such. Then the position emerges, your lordship will find, is para 18.
Yes.
Then which refers to Union of India versus Mario Cabrale. The position that emerged in the matter in view of different decisions of the Supreme Court up to 1982 may be summarized. So till 82 is summarized. Then, my lord, your lordship will kindly come to para 20. Taneja. Now, Taneja changes the law. Para 20. Then came in 1988 the decision of Taneja, 88-3 SCC. In that case, on an application such and such, then effectively, my lord, what the Supreme Court held was at the last sentence at page 294, paragraph 20. My lord, the quoted portion. When the High Court does not impose any punishment on the alleged contemptor, the High Court does not exercise any jurisdiction or power to punish for contempt. Jurisdiction High Court is to punish. When no punishment is imposed, it is difficult to say that the High Court has exercised jurisdiction in conferred to it under Article 215. It is observed the Supreme Court in that case that so long as no punishment is imposed, the higher court cannot said to be exercise jurisdiction. Now 21. It is thus be seen that the said 1988 decision of the Supreme Court in effect purports to knock out the court's 1974 decision on the question as to what point of time the exercise of High Court's jurisdiction to punish for contempt comes into play while deciding the contempt matter. Now, my lord, kindly skip a few sentences and take patently, the sentence starting with patently of that para 21. The 1988 decision also does not lend support to the proposition suggested in 1978 decision that if can order be passed, if it should be
if an order
is passed after the initial contempt proceeding or the contempt of order decides some dispute raising contempt asking it to drop the proceeding on one ground or the other, the same will be appealable under 19. Now comes the paragraph 22. It may, however, be mentioned here that the 1971 decision of the Supreme Court is a decision of two-judge bench, while the 88 decision is a decision of a three-judge bench of the same court. Consequently, in the case of a conflict between the two decisions, the 88 decision will prevail, being a decision of a larger bench. And to that effect, there is no difficulty in preferring the latter decision, provided the said decision is found otherwise applicable to govern the field. But pausing here for a moment, this takes care of the proposition, settled proposition, that when there is a larger bench decision, that will follow. Then the position, however, is distinctly different so far as 74 decision is concerned, because that decision is also a decision of a three-judge bench.
Like 88.
Like the 1988 decision. In this connection, we may refer to the decision of the five-judge bench of the Supreme Court of India in Union of India versus Raghuveer Singh, where it has been observed, it is the order to guard against the possibility of inconsistent decisions on points of law by different division benches that the rule has been evolved. In order to promote consistency and certainty in the development of the law and its contemporary status, that the statement of the law by a division bench is considered binding on a division bench of the same or lesser number of judges. This principle has been followed in India by several generations of judges. We may refer to a few in recent case on the point. Then, my lord, kindly take para 23. Now, I should also, my lord, point out the concluding portion, which is the concluding set out portion, which starts from we are of the opinion. Supreme Court observed, we are of the opinion that the pronouncement of law by a division bench of the court, of this court, is binding on a division bench of the same or a smaller number of judges. And in order that such decision is binding, it is not necessary that it should be the decision rendered by the full court or a constitutional bench of the court. Well, pausing here for a moment, I can show your lordship right now 5 judgments of the Supreme Court where a 3-judge has overruled another 3 judges. My lord, Justice Nariman has overruled not one, but several, 3 judges, saying that this is not good law. Be that as it may, my lord, not relevant in our purpose. My lord, our purpose, relevance is, I will be showing your lordship judgments of benches of larger strength, which is absolutely contrary to what has been held by the 2-judge bench.
If you are having judgment, which this 2-bench judgment is contrary to the full bench judgment.
And those judgments are old judgments not considered in the 2020.
It's not considered. That is
so first, to arrive at that, I have to first tell your lordship that this is the accepted proposition by a division bench of this court.
Correct.
So then your lordship can apply the division bench and then go to that test. My lord, here your lordship will see para 23. It continues the larger bench strength without troubling your lordship much, because we've touched 430. My lord, I'll just finish it here. My lord, kindly take the concluding sentence in para 23. The last 3 sentences of para 23. Consequently, for finding an answer to the question as to when the exercise of the High Court's jurisdiction to punish for contempt comes, we are bound to follow the principle laid down by the Supreme Court in 1974. In preference to that laid down in Taneja. So, both Taneja says absolutely opposite. But division bench of Calcutta High Court followed another earlier judgment of the coordinate strength. Then, but kindly, the reasons are also given at para 24. If we were to follow the decision in Taneja, we are required to dismiss the present appeal under 19. In limine, simply because the impugned order is not an order imposing punishment for contempt, and therefore cannot be said to have been passed in exercise of High Court's jurisdiction to punish for contempt. On the other hand, if we were to follow the 74 decision in Baradakanta, we must then find that the exercise of jurisdiction to punish for contempt has already commenced with the initiation of the proceeding for contempt, and therefore the present appeal against the impugned order passed after such commencement of exercise of jurisdiction is not liable to be dismissed in limine on the ground that no order has been passed. Following the 1974 decision in Boradakanto, once we find, as we must, that the present appeal is not liable to be dismissed in limine, for it's been an order of punishment for contempt, our next task will be to find out whether the impugned order passed in a proceeding for contempt, initiation decides such and such, such and such, such and such. Then, my lord,
appeal against the impugned order.
then, my lord, there is another judgment which has been referred to the last sentence at para 24. Our opinion in this regard also receives direct support from the decision reported in Purushottam, which is 78th Supreme Court, as well as from a recent decision of the division bench of this court in Gauri Shankar. So, I will stop here today for the moment, my lord. So, your lordship can, if I can satisfy your lordship that this issue, that statutory restriction on tenancy, there are judgments of a larger strength of the Supreme Court, then your lordship can follow that and say that Rajesh Mitra is not applicable.
Okay.
Of course, if it gets reviewed in the meantime, we are happy with that.
They started with opposing my learned senior friend and the first matter, item 1, and also the last matter. Last matter, item 1.
What a day.
But you have not cited the which is benefited to you.
No.
Which?
Conveniently.
Convenient.
Well, there's an interim order which is scheduled to expire today.
Counsel for the defendant has argued the matter at plaintiff has argued the matter at hand, but due to paucity of hearing could not be completed. Counsel for the plaintiff interim order granted earlier is today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 10th of September 2025 or until further order, whichever is earlier. No, 10th, 17th. Please the matter on. But time cannot be before vacation.
I don't.
But
the matter any day can be.
11th September.
It's a regular bench matter.
Yes, it's a regular bench matter.
Huh?
So
It's a regular bench
It's a
matter.
regular.
11th September.
Probably it is assigned to your lordship.
It's the assigned matter.
It is assigned to your lordship. It is assigned.
Assigned matter.
Assigned. Assigned.
Commercial.
Non-commercial assigned.
not only one difficulty, my lord. If my learned senior friend takes the next day, my lord, I do not have any objection. That's only thing.
12th September.
My lord, only one indulgence, my lord, from 4th of September. But I would, due to some medical emergency, I would not be able to, my lord, appear physically.
Till when?
My lord, either this side of the 4th of September or, my lord, could it be after the vacations, my lord? Because I will not be able to, my lord, assist your lordship appearing physically on and from the 4th of September, my lord.
If it is possible before 4th, any day, if subject to
only 1 week.
availability.
Because 2 days I will not be there.
Oh,
Okay,
yes.
I am fixing on 3rd. Let us see.
3rd of
If
November.
you get the chance, then you can argue.
3rd of
September.
September. If
3rd
we'll take a chance, we'll take a chance.
हम सुप्रीम कोर्ट 17 तक कराने दो.
Well, there is a matter where Mr. Sen is in some difficulty in the morning.
Your lordship had fixed 18 September at 12:30. And I had requested my learned.
I have no objection.
22nd, your lordship has fixed mine at.
Just a minute. 19 कर 19 कर दो और उसको 3rd रखो देखा जाएगा. 19 उसको 3rd रखो देखा जाएगा.
Today, the 12:30 fixed matter which Mr. Praval Mukherjee was arguing, that your lordship has fixed again on 22nd and 23rd at 12:30. So I was praying, my lord, if this matter can come on 22nd.
Instead of that.
Instead of that.
Wow.
1 day, my lord, because
It is fixed on 18th.
fixed on 18th.
So 18 you are a difficulty.
18th I have a difficulty.
No, 18th of this month. He is saying 22nd of next month.
No, 22nd of this month only.
22nd of September.
25 তারিখ আবার 20 তাই বলো কি রে ভাই আজকের ডেটটা ভুলতে পারছি
So instead of September में कोई date है?
September 22nd the date was given.
18th এ ডেট ছিল
না আমার একটা অন্য ম্যাটার
হ্যাঁ
সেটাতে ডেট ছিল
22nd September के 11:30 खाली है क्या? नहीं है.
किसको दिया? दे दिया.
No, your lordship has fixed my matter. I am saying that that can be preponed to 18th.
अच्छा, but other Mr.
I have spoken to Mr. Mukherjee, Probal Mukherjee.
हाँ.
Probal Mukherjee, they are agreeable with it. আজকে যেটা fix হলো না?
So that is 2 days. That is 2 days.
That is 2 days. The 22nd can be exchanged with this one.
This
matter can be.
Then in this matter also you are there. So how? So you will not be available
because Mr. Mukherjee is
arguing this matter. But that matter I will have to argue. That is why I will not be possible to come, my lord, on 18th.
कोई खाली है दूसरा?
Well, if that slot will get vacant, so
ना? 24 कितना बजे?
24 तो travel कुछ
24 September?
I don't mind. 24th.
24 तो travel कुछ very अच्छी ना 24 yes
Then it is
ठीक है
Record.
obliged.
As per the submission made by the counsel for ये वाला number ले लेना.
Indicated in
Counsel for the parties, let the matter appear on 24 September at 11:30. 11:30 instead of 18th September at 12:30.
Obliged.
Millard, if you have compelling circumstances, Millard, I have disturbed you. I am mentioning upon notice to both the parties. Millard, it's the statesman matter, Millard, which your lordship, Millard, by consent of the parties, at 2 p.m. was fixed it on 3rd. I had no problems with that. Now, Millard, after the mentioning got over, Millard, some men of Merlin have entered the premises forcibly and is trying to dislodge my archive. This has been sent by my client, addressed to my advocate on record with the documents and pictures. This is
No copy has been given to us. So this
down, a copy down.
is now being mentioned right now.
How can I give it without giving a copy? It's been written to just a minute. I have been informed by my office that 10 people from Merlin came to the third floor statesman about 2:10 p.m. and attempted to remove records and materials belonging to statesman. Please see photograph bearing the timestamp. Our senior staff present in the office advised me not to touch our property and asked them to contact either the chairman or manager without whose permission no material belonging to the statesman could be tampered. Backdrop shows our material, including old newspaper archive. Further, has just been informed that Merlin has disconnected electricity to our office to bring our operations to a standstill. Further, it has come to our knowledge that in the intervening night of 24-25th at 1:44 a.m., Merlin staff installed CCTV cameras outside our office. This was done without our knowledge at the time when our staff had gone after producer. The second one taken today is this one. Millard, the problem is this, Millard. I was under an impression that till such time the matter is lordship gets a chance to hear all the parties, Millard. Obviously, Millard, after only hearing at an interim stage. Now, Millard, if these developments take place, Millard, then kindly give some protection till such time your lordship comes back and is in a position to hear the matter.
Okay, if it is not, then I am passing an order to status quo, maintain status quo.
Your lordship.
So you are telling that it is a false, then status quo.
Keeps it tomorrow.
Tomorrow I am not, the court is not here.
The instruction kindly keeps it tomorrow.
Tomorrow
the date was
benches-
fixed by consent of all the parties. The junior was there. Now, if you were also informed of this earlier, this is now being shown to us right now.
This could have been sent with the mentioning
They
notice,
could
your
have
lordship.
shown us to this earlier. You
We
would
could
have
have.
this document to us earlier.
When the court is in sessions of hearing of the interim application, how you can do that?
Your staff's picture is there. Very well, Millard. Very well. Till your lordship comes back, give me some protection.
This picture that it doesn't appear that any person have wearing Merlin t-shirt or something is there. Doesn't appear Merlin person. Anybody can take a picture and then
This is
give a
not on an affidavit either.
As
It's
a
not
matter
an
of
affidavit
fact,
either.
Today is the matter. Matter was there.
Item number 10 is
They took time. They took time.
not be taken up in the
They
same
took time.
on 3rd September.
It
was
took
taken.
time.
It was taken.
I will record your, I will record, okay, I am not passing a note, I will record that any of the parties
are not doing
will
it.
not take any action for disturbing the possession. Tomorrow, how it can be?
Records that, Millard.
Okay, I will record your submission. You are telling that it is a false, so I will record your submission. It is not the defendants. They have given a false photograph. So the parties who are parties to the suit are directing maintain the status quo till the ad interim injunction is heard.
Kindly see the does it informed us of this beforehand. At 4:40 we have been given this photo.
This could have been sent with the mentioning notice or around 2:10 also.
Time at 2 o'clock.
With the
We-
did not send it with the mentioning notice. Now it is being handed up
We
to
came
court
to
at
know
court.
at 2. So this is an ambush.
इसका फाइल दो
Tomorrow, my lord,
फाइल दो though the matter is listed today as item number
10.
as item number 10.
It was again at their instance.
As item number 10.
With due consent of the
No.
junior counsel.
Yes, I
No,
did consent
understand,
because I did.
I understand. I see.
I
Item
did
number
consent
10.
because I didn't expect anything. I
But due
expected
to
a
paucity
gentleman's
of time, the matter could not be taken up for hearing. Full stop. When at the time of rising of the court, learned counsel appearing for the plaintiff, upon notice to the other side, has mentioned the matter and has handed over an email dated 25th of August 2025 received at 2:40 p.m. along with photographs, and submits that the learned counsel for the plaintiff has received an instruction and the information and email that the defendant, the Merlin pupils, have entered into the premises of the plaintiff and started disturbing the possession of the plaintiff over the suit premises. Full stop. Learned counsel for the defendants, you are appearing for whom?
For defendant number 1 for Merlin.
Learned counsel for the defendant number 1 submits that he has taken instruction and submit that no person from Merlin has entered into the premises of the plaintiff or disturbed the possession of the plaintiff. Full stop. Though the plaintiff has filed the suit along with an application for ad interim injunction, but the defendants have filed the caveat. Accordingly, the ad interim injunction is taken up for hearing on day-to-day basis. But due to paucity of time, the ad interim injunction hearing of the ad interim injunction could not be completed. The matter was fixed on 22nd of August 2025 at the top for hearing of the ad interim injunction application. But on the said date, the matter could not be taken up for hearing due to the bar resolution. Accordingly, matter was fixed today, but the matter could not be taken up for hearing. Full stop. Though the ad interim injunction is to be taken on ex parte basis, but in the present case there was a caveat. Accordingly, the notice was issued to the defendant, and the defendant is contesting the prayer for ad interim order. It is the knowledge of the defendant that the court is in session for hearing of the ad interim injunction application, but it is unfortunate that the defendants are alleged to have disturbed the possession of the plaintiff or the premises in question. As the defendant number 1 is denying the allegation made by the plaintiff, in view of the above, this court finds that till the ad interim application is not been heard by this court, the parties should be directed to maintain status quo with regard to the nature, character, and possession of the property. Let the matter appear. क्या डेट दिया था इसका? 3rd September.
Your lordship, in your order, it's defendant number 1. The allegation is in defendant number 1, I guess. I am defendant number 2, so it may have
Maybe
gone.
both, any.